lords. Quickly, a memo for being spoken to, my lords. Your lordships allowed one writ petition directing KEA to refund the petitioner's fee of 67 lakhs and also directed to pay 6% interest. But that 6% is missing from the order, my lords.
Yes. Any mentioning?
Lord, serial number.
List 1, page 1, serial number 1 to 3. Page 2, 4 to 9. Page 3, 10 to 11.
Serial number 10, my lord. In the 10.2, I have filed a bringing a loss application, my lord. I'm for the petitioner. That IA was not put up, my lord.
There are other matters, please mention
Please,
when it's
please,
covered.
ma'am.
Yes.
Page 4, 12 to 14. Page 5, 15 to 24. Page 6, 25 and 26. Page 7, 27. Page 8, 28. Page 23, 29 and 30. Page 24, 31 to 38.
32. Office objections.
Yes, ma'am.
Fourth time. For office objections for the fourth time.
Yes,
You are for
ma'am.
the appellant. Yes,
Serial number 34.
please do it in the meanwhile.
Serial number 34, ma'am.
Yes.
34.
Hmm.
1 minute time.
Again, fourth time.
1 minute. Final.
Page 25, 39 to 42.
Serial number 39, my lords. Kindly have it on a week, my lords. Serial number 39,
39.
please.
Office objections. Third time.
Please, my lords. Kindly have for a week, my lords.
Hmm.
Red flag.
Page 26, 43 and 44. Page 27, 45. Page.
My lords, 46, my lords. I'm for T. Basuraj. He's my friend, my lords. There's some function, so kindly, I pray, my lords, for some time, my lords. I'm his friend. He's my senior friend, my lords.
There are other counsel involved. Have you informed them that you're seeking
I
an
will,
adjournment?
please, I'll do the needful, man. I'm actually visually impaired. I'll ask my senior friend to do the same.
Please
kindly,
do
my
that
lords.
and don't make submissions in the morning without informing the other side.
Please, I apologize, my lords. I apologize.
29, 47. 20, page 35, 48.
What about the other case?
Some cases I am appearing to the appellant. It's the same conflict. Either we are appearing to the respondent or the appellant in either cases. Because the order of the learned single judge has been questioned by both of us.
No, the question is only this, have you informed the other side?
Yeah.
You have.
I did say I will inform, but if you want the particular date, what can I request on 20th next week?
Yes.
Page 36, 49. Page 37, 52, 53.
Lords, kindly, my lord, serial number 53, appear for the petitioners. My lord, the respondent, my lord, they want to file an objection, my lord. Lata Shetty informed me, my lord, she will be taking time.
That's
Only
R5
R5, my lord, for Rajiv Gandhi University.
and R6.
My lord, they have not filed. My lord, my only request is, my lord, I have filed a IA, my lord, to announce the result. This honorable court, my lord, had permitted us to take the exam. Let that IA be posted in the next week at least, my lord.
Yes, we see that the IA is listed.
IA is along with the petition, but on the last occasion we made a submission, but my lord, but it is again come in the, not in the IA list.
Yes.
Any convenient
What
date?
about the connected case?
It's the same, my lord. In the connected case, I have filed a application, my lord, to announce the result. That might be posted in the hearing on IA, my lord, any convenient date.
There is, the IA is listed.
IA is listed today, my lord, but it's come for final hearing.
Yes.
Twenty-seven.
Obliged.
List 2. Orders, bill number 1. Vivek Holla.
The respondent statement.
Settled, yes. The report is before me.
is submitted by the learned counsel appearing on either side, that pursuant to the reference made for, to mediation, the disputes between the parties have been settled, and report to that effect is placed on record. The report of the mediator, along with the memorandum of settlement entered into between the parties on 28/10/2024 is on record. The report as well as the memorandum of a settlement is accepted. The writ petition HC is disposed of accordingly. The memorandum of settlement entered into between the parties shall form part of the judgment of this court in the WX.
So number 2, Vishnu Hegde.
Yes. Petition. There's an habeas corpus petition filed by the father, my lord, of the child. And I'm sorry. I appear for the petition. I don't know. My learned friend want to argue for the petitioner. Let him argue. I have no objection.
Husband and wife are fighting their case before the competent family court.
Lord, I appear for the petitioner. Let me make my submission. I don't understand my learned friend.
What is the prayer here?
Where is my child should be restored to the father? The child happened to be a
Foreign
citizen of
Canadian
Canada
citizen.
and is a foreigner. There's a case. My lord, I have produced all the documentary necessary things and as well as the apex court's
Passport.
orders also totally in support of us. I may make submission.
Hmm.
The child was born in Canada, my lord. He's about 3 years, 3 years old son. And they both were living in Canada. After some time, my lord, we wanted to visit India along with the wife and child came to Bangalore. Karnataka and Damagere is the place they reside. After return ticket is also being purchased by me for the wife and children and me. All the 3 are supposed to go. The wife refused to come back and join us while getting back and refused to hand over the child. Later, she filed an application for custody of the child and all that in Damagere and divorce petition and all that is pending. There is another aspect of the matter. Now, this habeas corpus which I have filed is the child is a citizen of Canada and his child, the petitioner child, it has to be restored back. Is a short question. Now, my contention of my learned friend is the matters are pending there, thereby let them vegetate is not the question. It has been subtly legal.
Yes,
This is a subtle legal proposition made by the Supreme Court itself. I don't understand how they are opposing the Supreme Court's order itself without going through it. I'll produce the copies of the orders passed by the Honorable Apex Court, my lord.
in your case,
Yes, ma'am.
in your case, no. In your case,
In my, no, not the very case, not the very case.
yes.
But I, to that answer is, barring the name of the parties, the remaining things are the same.
Yes,
I'll just pass on the copies, my lord. Okay, 1 ನಿಮಿಷ. Yeah, your name.
is this Vasudha Sethi that you're referring to?
Sorry,
Is it Vasudha Sethi that you're referring to,
No, no,
the judgment? No.
not Vasudha Sethi. ನಾಲ್ಕಿದೆ, ನಾಲ್ಕು ಕೊಡ್ತಾರೆ. ಎಲ್ಲ ನೋಡ್ಕೊಳ್ತಾರೆ.
this is the case, a similar setup as.
ನಮ್ಮದು ನೀವು
The parents are Indian citizens?
Just.
Parents are Indian citizens?
No. Father is Canadian citizen.
You have a senior counsel representing Yes.
Passport
the-
and everything is at Canada.
Even child's passport is also Canada.
That is not the question.
sorry.
Are the parents Indian citizens?
Father is in
Citizen
Canada,
and that.
mother in Davangere.
Wherever they are, council, please answer the question. Are they Indian citizens?
Yes,
Yes.
yes,
ಇಲ್ಲ.
Indian citizens.
He is not an Indian citizen.
Child is only a Canadian born, Canadian citizen.
Father is also Canadian citizen.
Father is also Canadian citizen. I stand corrected.
Citizenship of the child. It will be welfare of the child.
ನೋಡಿ ಇಲ್ಲ.
Yes.
Yes,
Yes. Now, what is the reason for you to file this habeas corpus application, please?
the child was
You're already before the family court
No.
with regard to custody.
later. I
So now
filed
what-
this. What has happened, Miller, I just mixed.
Hmm.
The wife filed a petition before this honorable court
Hmm.
seeking for visa to be extended
Hmm.
without notice to the husband.
Hmm.
This honorable court granted visa till January.
Hmm.
That's aspect of mine.
Hmm.
That now I have also challenged by objection that is pending there.
Hmm.
The custody was asked, which since custody was refused to be given, handed over by the mother,
Hmm.
I was compelled to file a petition before this honorable court seeking for habeas corpus.
Hmm.
Number one. Number two, earlier to that, my lord filed a petition before the Canadian court asking the custody of the child. Court also passed an order there
Hmm.
and issued notice to the other side. That is also pending.
Interim order is in our favor.
The interim order
grant
also passed by the
custody.
Canadian court is in my favor.
How old is the child now?
3 years.
3 years.
4
years.
4 years.
Hmm. Yes. Are there any objections on record? You want, you have filed objections.
Court
Mm.
said the summary inquiry is required. That is not maintainable.
Hmm.
Really.
Hmm. Hmm.
Even the contestant to appear before Indian court and even two representatives of Fred Miller,
Hmm.
tendency of the divorce petition has been treated even in the record petition.
Hmm.
Spite of it, he did not choose to appear before the Supreme Court and now.
Citizen of some other country and it is applicable to the Indian citizens.
Hmm. Hmm.
In such circumstances only, this is the judgment, sir.
Is there a judgment in this
Yes.
case? Not, is there a judgment? You said judgments are not binding. Is there a judgment in this case? Counsel, is this case, is there a judgment? Yes. Hmm. Where is your memo? When did you file your objections, please?
ನಮ್ದು ಮಾರ್ಕ್ ನೀವು ಅಲ್ಲಿ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀರಾ ಇಲ್ಲ ಸಿಕ್ತು ಅದಕ್ಕೂನು ಒಂದು ಸೆಕೆಂಡ್
Even in the even though it's a party, it's not good for me. By avoiding all those things,
Yes.
Here, purpose in this nature is not maintained for the reason that there is no where to pay it. The matter is said before the family, but family court has to adjudicate the matter by the court.
Yes.
So these are the factual aspects cannot be decided in here. In reply, my lord, only one sentence which I wanted. This aspect has been settled by this Honorable Supreme Court, including saying that the matters are pending before the subordinate court. Even then, that is immaterial. That's what is the Honorable Supreme Court says.
Where does it say?
Sorry, madam.
Where does it say? Please read out.
That all that, those aspects has been discussed. May come, you will ask, kindly turn to page 384, madam. There are two judgments. One I have now produced.
Hmm.
Page 384. 12 para. Bottom.
Hmm.
May I read, madam?
Please.
The respondent arrived in India with a child in March 2019. The appellant filed a custody and for return of the minor child before the Superior Court in New Jersey,
Hmm.
concerned country, division, family part and so date.
In that
And-
case, the appellant is the father.
Yes,
Hmm. And the respondent in whose custody the child is the mother.
correct.
Hmm.
And awarded the temporary custody on
Hmm.
21/5/2019.
Hmm.
On 10/7/2019, the appellant filed a a petition under under Article 32 for the Constitution,
Hmm.
seeking the writ of habeas corpus before this court.
Hmm.
This court granted the appellant liberty to move the appropriate forum. Therefore, the appellant filed habeas corpus petition before the High Court of Karnataka on 13/8/2019. The above sequences of events makes it evident that the appellant has accepted promptly to secure the custody of the child. In such an event, this court is only required to conduct summary inquiry to ascertain whether there is any harm if the child returns to the event where he was born and he has been brought up. The court is required to engage in an elaborate inquiry on the merits of the case only if a considerate time has passed since the child has been removed and if the child is developed roots in India. In either event, the primary consideration of this court is to ascertain the welfare of the child. From then, my lord, I'll come to the directly that aspect has been discussed. Now coming to page 388, para 18, my lord. Conclusion which arrived. This is also 3.5 years old child.
Hmm.
Before concluding, the court records its appreciation of the object of the assistance rendered by so and so. He was appointed as amicus curiae. Having thus heard the counsel for the appellant and the amicus curiae, we are of the view that the condition which has been imposed
No, please, my lord.
Effect of the security deposit.
Please, my lord. Please, my lord.
30 lakhs.
Please, my lord.
So what was the
Kindly
Well-
pass over, my lords.
But the entire, my lord, is the only contention, lords, is that that was received by us as an appellant as a security deposit in lieu, my lords, of the property that was leased out to them, my lords.
correct?
The honorable,
Their contention is that there were arrears of rent.
please,
which
my lord,
Was to be adjusted to this amount.
please, my lord.
What was there to show that there was arrears of rent?
My lord, that's what the honorable court, my lord, says. The lease, according to them, was for a period of 9 years.
Hmm.
But in terms of section 107 of
Disturbed.
it's not registered. The photocopy of the same has been produced before the court. But the court says, I can't look into documents, and even otherwise,
Hmm.
if the rigor of law requires that a document be registered, it ought to be registered. In terms of section 107 of the TP Act, with 39 and 49 of the Registration Act and the Law and Provision of Stamp Act.
Hmm.
So the court says the only document for them to show that they're in receipt of 30 lakhs of money in lieu of the property that they have leased is the alleged lease deed,
Hmm.
which the court cannot take cognizance of for various reasons.
Hmm.
Hence, my lord, in terms of section 5 and 3 of the KPIDFE Act, lords, the attachment made by the government of Karnataka under 3.2 has been made, my lord, absolute.
Hmm.
It is this order that's in challenge before your lordships, my lord.
Now, their contention is that there was an earlier application with regard to the property.
Please, my lord. That was, my lord. The honorable court also, my lords, very categorically holds that
Will not make a difference.
will not make it's not bound by res judicata because
Unless they can prove that this amount is due to them as arrears of rent.
please,
That would be the end of it.
please, my lord.
My lords, kindly pass over, my lords.
So, no, pass over today, some other day. Yes,
Obliged.
list on some other day.
My lord.
If you don't pay the amount, you don't get your property back. That is all.
But we're not
Yes.
even claiming the property, my lords. We're only, my lords, as far as 30 lakhs is concerned, my lord.
Yes.
Obliged.
Obliged, please.
Notes for the respondent gave it, my lords.
My lord,
Library supervisors.
indeed.
Yes, my lords.
Now there is a
Pages
notification.
notification
Yes,
5/8/2016. Your.
there is a new
but-
notification, my lord, now accepting paying the. Now the learned AG has requested me to pray for 2 weeks' time to calculate the arrears and place before this court, my lord. May be taken up after.
My lords, regarding to arrears of my lords, I may be permitted to submit 2 points on it, my lords. Before the learned single judge on 11/8/2021, my lords.
Mm.
In the during daily proceedings, my lords, the learned single judge, he had directed the respondent government at the pendency of the writ petition, as the petitioner library supervisors are entitled for the remunerations from the date of 5/8/2016, wherein the notification issued
Till the date of.
till the 2017 notification,
Yes.
where it was removed.
Hmm.
And calculate and disperse to the petitioners
Hmm.
to that aspects. Now.
That has been
But-
calculated and submitted? No.
That was not done. And the petitioners before the learned single judge, they filed the memo of calculation also, my lords.
Now, as a matter of fact, after the fresh notification, you're receiving it.
Remuneration, I am receiving as per the fresh notification, not, but the earlier one, my lords.
Arrears will
Yes,
calculate and
Lords.
place it within 2 weeks.
Learned government advocate.
To that, my
seeks
lords, one
2
more
weeks' time
submission.
To place the calculation with regard to the arrears of wages due to the respondents list after 2 weeks.
My lords, one more
Place it
submission.
on record.
One more submission may kindly be noted. After that, my lords, in the very next proceedings, my lords, on 5/10/2021, till that day, no calculation was submitted by the respondent government. Taking note of that point, my lords, the learned single judge further directed the respondent government to file an affidavit why it was not done. And within 2 weeks, my lords. Subsequently, if within 2 weeks same is not done, affidavit is not filed, and also a disbursement is not done with respect to remunerations, petitioners are entitled for 2,000 each, my lords. That was also passed in the writ petition proceedings, my lords. Same may kindly be noted, and
They
Let
are
me
an
up-
appeal as against that judgment. Counts. Let's see.
please, my
Let
lords,
them place it on record. We'll see.
please,
We'll
Grateful.
hear you on that aspect.
please. my
Yes.
lords.
Grateful.
In this case, I appear for appellant. my lords.
Power Grid Corporation of India.
Yes, my lord.
The respondents had purchased the properties on 9/7/2015.
Yes, my lord. My lords,
With
what-
regard to your notifications, this is only for
Drawing
for
of
the
lines.
drawing of lines. Is there a notification provided by the Act This is under the Electricity Act that.
No, under the Telegraph
This is
Act.
high tension line
High
is
tension
drawn.
line. This is a Telegraph Act where the line has been approved by the, there will be approval given by the Union of India, my lords. They will give the, under the Gazette, they have been given a powers to draw the lines, and the line has been approved, and the sketch and everything will be provided to the authority, and they will approve the sketch and everything.
Is simply this, council. Is it notified? Does the landowner know?
Yes, my lords.
How?
No, it will be published in the newspapers.
Please tell us what is the provision of law with regard to that.
My lords, under 16, under 10D, my lords, it is the line, powers has been given under 16. Under 10D of the Telegraph Act, my lords.
This is the power, we understand. Now, where is the procedure with regard to the issue is only this, whether the finding of the learned single judges that the entire value of the property is lost. Question is only this, when they bought the property, were they aware that there is any such proposal?
Whether the notification, my lord.
Yes, is there a notification provided for in the act? If there is a notification and if it is notified, then they cannot raise these contentions, which is what we are asking you. We did not find anything in your pleadings with regard to any notification.
Under 68 of the Electricity Act, power and approval has been given to the authority.
Then what happens?
Annexure R2 135.
Annexure?
R2, my lord, page number 135. There is a approval. There's a line has been also given, ma'am. Prior approval of the government under section 68 of the Electricity Act 2003.
It's scanned, but it's not, there's something wrong. Page number?
135.
One
135. There's an approval, ma'am, under 68 to the lines. The Salem Somanelli 400 kV.
Sorry, this is not what you're saying it is. 8/5/2015, the translated copy says it's a spot inspection report.
Annexure R2, madam.
Give me annexure R2 here. Please verify what you have given us. 135 does not have any of those. Where is your objection?
Sorry,
When did you
madam.
file it?
155, sorry, madam. 155, sorry. Sorry, madam. 155.
Yes.
Based on this approval, my lords, as to a landowner, I knew about the drawing of lines.
The approval is subject to compliance of requirement of the relevant provisions of the Electricity Act 2003 as amended from time to time and the rules and regulations framed thereunder and the rules governing overhead lines as specified in the Indian Electricity Rules 1958.
Yes, madam.
Please
This
provide what, please tell us what the provisions are. How is the notification effected? How is the, you also say that the employee has not, the owner of the property has not withdrawn the compensation. Is not.
pardon, my lord.
the owner of the property has not withdrawn the compensation.
Yeah, he has withdrawn early, it has been paid to as well
Says that he has not.
Yes,
The
ma'am.
judgment at least records that it is not.
Yes, ma'am.
Nothing has been withdrawn by anybody.
Yeah, yes, ma'am.
So please provide what the provisions of law are. You're arguing a writ appeal.
Yes, madam.
Yes, the learned single judge finds that the entire property has lost its value because of the overhead line and cannot be used. Therefore, what is the provision? And once it is notified, whether that means that everybody is informed that there is a constructive notice to everyone concerned. If there is a 2010 notification, then that is the end of the matter.
Very well.
Yes. Learned counsel for the petitioner, I mean, for the appellant, to place the relevant provisions of law and materials on record. List after a week.
Yes, ma'am.
For the appellant. Parties have resolved their dispute, my lords.
They have.
I request for passover, my lords. 2:30.
Yes.
They report the settlement.
2:30 may be a little late today.
Okay.
Yes.
Great.
Notice to respondent held sufficient, but no appearance for the appellant. Husband's appeal. Yes. Listed on some other day, please.
The appellant in the matter, my lords.
For respondent.
Serial number 31 also is a connected matter, my lords. There are two petitions which were filed, one by the wife for restitution of conjugal rights, as against the dismissal of that, this present appeal. The husband also had filed a divorce petition, which was also dismissed, my lords, as against the serial number 31. My learned friend has, I have requested him to take notice.
I'll take
Because the
notice.
parties
Yes.
are the same thing. There is a chance of settlement, my lords. My only request is, I've also spoken to my learned friend. If my lords would please to send it to mediation in Bangalore, both are residents of Mysore. At least in Bangalore, we have a fair chance that we can explore any possibility, my lords.
Please, me.
Agreeable?
Yes, me.
Yes, so and so learned counsel takes notice on behalf of the respondent. Call along with item 31. It is submitted. MFA 5122 of 2023. It is submitted by the learned counsel appearing on either side. If the matter is referred to mediation, there is a fair chance of settlement of the dispute between the parties. So, the overview of the matter. That is admitted matter. This appeal is also admitted, list along with MFA 5122 of 23. The parties are referred to mediation before the Karnataka Mediation Center at Bangalore and shall mark appearance on
26th is my request, my lords.
26th.
26/11/2024 at 3 p.m.
3 p.m.
3 p.m.
Please
Grateful.
list the matters along with the report of the mediator. Notice has to go? It's fresh.
Fresh matter.
Yes, notice. List immediately after service is complete.
Of that.
Wife's appeal. Fresh notice has to go. No,
it-
there is,
Caveat
oh,
has
there
been-
is caveat.
Caveat had been filed since 4 times. They have not appeared before this honorable court. With respect to
Yes.
custody of the child. Now with the grandparents,
How old is the child?
4 years, 10 months.
When did the mother pass away?
Mother passed
Child
away
bo-
on
child
6,
Born on 5/12/2019.
mother passed away on 6/1/2021.
Hmm.
1 year, some old. Then onwards, he started staying along with the grandparents, maternal grandparents.
Is there, are there any allegations?
Allegations are there and complaint came to be given by the maternal parents and it was not registered and PCR came to be filed. in the PCR B report has been filed and objection raised before the jurisdictional court with respect to B report. Now it is pending. Only paramount interest of the importance of the child's
How old are the grandparents?
grandparents nearing 60 years. They are taking care, they admitted the student, this child to the school. He's going to the school present.
You're interacting with the child over telephone?
Or telephone and visiting rights are there, and
That is
that can be continued. I am the grandfather of the child. I am the grandfather of the child. Child is in my custody.
Oh. Yes. No urgency in the matter.
My lord, because execution is pending on 18th, 19th, it is coming before, and court below specified that without any interim order, it may be difficult for us to.
Heard the learned counsel for the appellant. When was the last date of posting? Respondent has appeared.
29.
One date. We'll have it on Friday. List this on Friday, please. If the, please record that the learned counsel for the caveator respondent is not available. List on Friday. Let's see. Hmm. 2017 writ appeal. And tribunal. No appearance for the appellant. List in the usual course. Yes. 393 days.
Yes, my lord. In this case, my lord, 10.2, I have filed an application for bringing LRs. That application was not put up, my lord.
Yes.
The last date of also I have submitted this.
Yes. 2013 matter.
2013 connected matter is there in 10.2 that, yes, in that I have filed a LRs application. And filed on 2023, my lord.
Yes. The registry shall put up IA, if any, filed in WP 75331 of 2013 for consideration on the next date of hearing. List after a week.
Please.
But in this matter, my colleague, government advocate who is appearing in this matter, my lord, she has requested for some time to secure certain instructions relating to implementation of the ACT pay skills in other institutions. I'm told that the litigation conducting officer of the government is suffering from dengue and he has not been able to provide information. Therefore, if it can be taken up.
On the other hand, your lordship may kindly consider these are senior citizens. They don't know whether they will survive or not. This court had already concluded to dismiss the appeal filed by, which is frivolous, which has come after that. And the second thing is they have paid the same AICT salary to all engineering college. Only the pharmacy college is left out. It is not that the government adopted AICT scale, did not adopt AICT scale to pharmacy. Only the time first for engineering college they are given full. For this they are delayed for 7 months and then paid. That cannot happen.
What is
And
the
in
finding of, just a moment, what is the finding of the learned single judge?
Huh?
What is the finding of the learned single judge?
Learned single, it is a consent judgment. And as per the first appeal is concerned, your lordship had already concluded that is infracted.
Just a moment, counsel, what is the direction in the judgment?
No, your lordship, which is, in the writ appeal, there are,
Consider the representation. and to pass
they have
the-
considered that representation, and that representation was
Told that the
challenged, and again, the
Officer,
judgment was passed.
because of
So
his
once,
illness,
Moment, counsel.
the officer, because of his illness, she had sought some documents, my lord. The learned counsel who was appearing in this matter.
The learned government advocate seeks a short accommodation.
this is the
on
third
ground that
occasion
the
on,
learned counsel, learned government advocate who was appearing in the matter is indisposed.
No, the government officer could not give the instructions. He is suffering from dengue. If the he's suffering from dengue, I'm told, my lord. She has
The
requested some
officer
alternate
is-
officer to come and give instructions.
The officer who has to
The litigation conducting officer, my lord. He is
Give
suffering from dengue.
instructions.
your lordship,
is in-
this court also have taken,
After a week, what happened after the direction?
what happened direction is they consider the direction saying that the government is not in a position financial situation and they rejected that. That was challenged in another writ petition. That writ petition was allowed. When the writ petition was allowed, they did not comply. So contempt petition was initiated. When contempt petition was initiated, the government advocate tried to bring that there is an appeal. So the court took serious note and imposed to deposit 20 lakhs to show the bona fide, because the court has
Has
come.
been deposited.
Yes, the court has, and the court has also inclined that this will be imposed as cost to the government. And thereafter, this miscellaneous appeal, which was dismissed for non-prosecution, after filing of that appeal, they tried to see that this appeal is restored, which was nearly 3 years old, and which was, and there also they have concealed the facts, and they got the appeal restored. And this court, on the first inclination, only said that the appeal is not maintainable. It will.
Which is why they want time to get instructions in the matter, counsel.
No,
Yes.
I just bring the facts to your lordship had expressed that view, so that I just highlighted that view.
My lord, may I just have one more request, my lord. If it can be taken up in the first week of December, my lord. I mean, my lord, no further adjournments will be sought, because the additional information which is to be filed, my lord.
No, if as a matter of fact, you have to, this only says the direction is to be, the representation is to be considered. The representation is considered rejected, that has been set aside. If you're seriously on the question, then it is that writ appeal which has to be considered, not this. This is virtually infructuous. This appeal is infructuous. And then in that, there is a 230 days delay in filing the appeal, which is the appeal in which in the case where orders have been passed, you did not file the appeal in time.
I've been asked to request. for
Throughout
that
the
date, my lord,
country,
and
only
no
this,
further time will be sought is
this
what I'm-
college has been, I have
It can
not
be
got.
taken up on 5th of December, my lord. No
In,
further time will be sought. It will be concluded on.
In Orissa High Court like this,
Good
the
on that
court
day.
has directed to pay immediately the entire, because they are all senior citizens. They have worked honestly and they are liable to get. It is not that the government cannot pay that. That is the reason recorded by this court.
In view of the submissions made by the learned government advocate, the matter is listed to the 5th of December as a last chance.
Grateful one.
If it is not argued on that day,
We will argue.
yes. ACT. Yes. Yes.
Correspondent 1 and 2 listed.
Hmm.
The direct issue was non-issuance of Mata. The other of the rate was.
Hmm.
Last section, had said that the instruct provision not yet issued. Not,
I'll seek, 2 weeks of time, I'll seek instruction.
Yes. The order sheet, please. Nothing survives here. Nothing survives here because they say that they've paid the amount. You still don't change the khata. What the court said was you have a claim, you may have a claim for betterment charges, but the khata cannot be withheld because of that. You can claim the betterment charges, but no, if that is not done, this amounts to contempt of court. Why is it not changed?
I pray 1 weeks of time, I'll seek instruction.
No, there is already an order, counsel. This was listed specifically for your instructions today.
I pray finally 1 weeks of time, madam, so that I'll make necessary submissions.
They say the balance amount, there was an interim order, a portion of the amount was paid. They were permitted to seek change of khata. They made the requests not done. They say they paid the entire charges. Whatever is demanded by you, they've paid. Now, what can be the reason for
In this regard, I pray only 1 weeks of time finally, so that I'll make my necessary submissions and.
learned counsel
this
for the
petition
respondent
can be
submits
disposed of.
that instructions have not been made available by the respondents in spite of the previous order passed by this court on 28/10/2024. 2 weeks' time is granted as a last chance, failing which we'll impose cost counts,
I got it.
failing which cost shall be imposed
So grateful.
on the respondent, list after 2 weeks. Hmm.
13, my lords, I am appearing for the appellant in this.
Yes,
Appear for the
My lord.
fifth respondent.
I appear for respondent number 1 to 4.
yes,
Raise short accommodation, my lords.
just a moment. BBM.
Lecturer,
Yes,
I praise short accommodation, my lords. My senior is not keeping well. He is suffering from conjunctivitis.
when do you want it?
10 days, my lords.
We listed in the first week of December, my lords. It's 2 weeks.
But actually, my lord, there is nothing in this matter, I would say respectfully. Of course.
Essentially, what we had submitted before the learned, lords, a finding of fraud is returned by the officer who's passed the order without upsetting the order, the finding of fraud. The learned single judge says that the benefit of the fraud should continue in the name of the person who is the beneficiary. That could not have happened, please. There was nothing for the learned single judge to have intervened.
Yes. The learned counsel appearing for the BBMP
Please, my lord.
seeks a short accommodation. List.
Lordships.
Grateful.
To be heard on this.
Still number 14,
Yes,
I'm not, can I seek a Passover, I'm not, in the afternoon? 230 LR. Short accommodation.
Can it be after?
Certainly.
Yes, pass over.
Yes, certainly.
There is a 145 matter after which, I mean, 230 matters
240.
after which.
Yes, Lord. Yes, please.
Obliged.
Hearing on IA.
Yes, notice has to go.
In this matter, I appear on behalf of the appellant counsel, my lord.
Notice,
Notice has already ordered, my lord.
notice has not been ordered, counsel. MFA 2615 of 23, notice has not been ordered.
If it is
Notice.
serial number 15, my lord.
Yes. You're for the, yes, notice not ordered as yet. Issue notice.
Much
Just
obliged.
immediately after service is complete.
16, Prakash KN.
Item 16,
Delay
served 64 days.
For the
My lords,
respondent,
sorry, my lord, I am at 16.
Are you sure?
Yes, my lord, 64 days delay.
Yes. Can it be, can
Yes,
the
madam.
delay be condoned?
Yes.
IA number, so IA 1 of 2023. This application is filed for continuation of delay of 64 days. 1 of 23, yes. 64 days in filing this appeal in view of the submissions made and the averments in the affidavit filed in support of the application for continuation of delay. The delay of 64 days in filing the appeal shall stand condoned. List for admission.
My lord, I have one submission to make. The addresses in the cost title, it's not right. So we have not received the certified, notice as well. So copies may be ordered to serve.
Yes. Please serve a copy for the
Yes, my
copy.
lord, sir, we will serve the copy.
Copies of the appeal and all connected.
So far,
records
they have not even paid a single rupee of maintenance while
shall be
the
made
child is
My
suffering from
lords,
heart disease.
Please make available the copies. We'll list it.
yes, my lord.
Yes.
They are giving other address.
It's
Already they sold the property and they are giving same address.
no.
Yes, please serve a copy.
Yes.
17, yes, Nagaraj.
Notice 1348 days notice.
18, Vikas M.
Yes, 303 days notice.
19, Ajit PB 43, notice.
Notice.
20, BD Surana.
Notice. Notice. Yes, notice is permitted to be taken out in fresh address as well. Which is to be furnished. Yes, 21 also
Usha
notice.
Devi.
Notice.
22,
Notice.
23,
Notice go and come. 126. Yes. Sorry? Yes, notice.
23, Devendra
Notice.
N.
As well. In addition. If you are very confident, we can have it. Yes.
27th, Becca.
Wakalat will have to be filed. They must be ready for the settlement. Yes.
Is there anybody appearing today on their behalf?
I already informed and they.
Whether any advocate is appearing today?
Already informed and they will take time to 27th this month. That's why. Obliged.
She notice in addition is permitted to take out through the council appearing in the court. I know.
Orders, till number 24.
Lordship.
For mediation and requirements of mediation. All their acceptance speech and then make assignment. That is the little-
Non-central government. ಈಗ ಗೊತ್ತಾಗಿದೆ ತೆಗೆದು ನಾನು
Correct. Which is why it is better than it used to be.
Lordship, I'm appearing on behalf of central government, my lord. I just received nomination yesterday. 1 week, any date may be fixed, my lord. I will.
Is that issue with regard to refund?
Yes, ma'am.
Only with respect to the documents where we have filled the seats after the cutoff date.
I will answer this.
Yes, learned
Lord,
counsel appearing for, you are for the
Other paragraph 6 ಅಲ್ಲ.
R5.
Yes,
Learned CGC appearing for R5 seeks a short accommodation to place his arguments on record.
Yes, ma'am.
List after a week.
Yes, my lord. 2 weeks, my lord.
Objection for this. On file of the amended constitution. On 7/11/2024, I filed the amended petition.
It is submitted by the learned counsel for the petitioner
ಅದೇ ನಾನು
that the amended petition is already on record
direction ಏನಿದೆ?
as on 7/11.
7/11/24.
7/11.
My lord, in this, my lord, in that application, my lord, they have spelled out so many things which are not relevant. My lord, the only thing is, my lord, whether the college have filled the seat after that cutoff date, only those things. My lord, in that application, my lord, they have asked for what are the regulations for filling up the seats, the brochure of the college, everything was, that is not, that may not be relevant, my lord. Only that the admission.
No, that is the prayer that they've made.
Applications,
That is only the prayer they've made. We have not allowed it.
please, my lord, but the application says so, my lord. we have
Yes,
to get the clarity.
I'll place on record what is.
yes, what is relevant?
Yes, my lord. My lord, my name Gautam Dev Sivulal may be
Yes,
shown.
please show the name of the CGC in the cost item list after 2 weeks.
Obligement.
28. 25, government advocate.
Yeah, for the respondents, my lord.
I pray for 2 weeks time, my lord, we'll file the amended cost in the meantime.
Amended cost
Ma-
item,
Maybe taken up for admission on the next date of hearing.
recalling order date, what is the order date in
My
98?
lord, some of the respondents were deleted at the instance of the other respondents.
Yes.
And the government
You require,
by
them.
oversight consented to that.
You want them,
We want.
yes.
But your lordships have already, my lords, in fact, the recall application was already allowed on the last date. I think
Therefore,
the
the
cost title is not reflecting that, my lord. Already allowed. So there may not be any need to now amend the cost title. They will only have to take steps to serve those respondents.
That's correct.
Maybe taken up after 2 weeks.
Yes, since the order dated 19/8/2024 stands recalled,
Yes,
there is no requirement for filing amended cost title. The appellants shall take steps to serve the unrepresented respondents in the writ appeal. List
My lords,
after, list immediately after service is complete.
My lords, may I make one request on in that regard, my lord. My lord, they may please send them by hand because this dispute relates to the year 2006, my lord. My name is removed from the revenue records. I've been successful all through.
Yes,
Please.
the appellant is permitted to take notice to the unserved respondents. By hand? By hand, we can permit. Appellant shall take out notice. Is permitted to take out notice by hand.
by hand.
You don't have to file the amended cost title because that does
Please.
not arise anymore. Please serve them by hand.
Please.
List on, please give a date.
Grateful, man.
Please see that steps are taken.
Please.
28/11.
Please don't show that IA is pending anymore. It is being shown as pending. IA 1 of 24 is the IA for record. IA 1 of 21 is the order which. Subjections also, deletions also. Yes. IA 1 of 24 is the IA. No, the IA is 1 of 24. The last IA is 1 of 24. That is allowed. And the order on IA 1 of 21 is recorded. Please correct this. Please make the corrections and see that the IA is not put up anymore.
IA 1 of 24.
IA 1 of 24 is the IA for record. That is the one which is allowed. It appears that by mistake it is noted as 1 of 21. Probably is the, yes,
26, madam.
26.
My lord, in
Item 26.
26, I appear for the petitioner, please, my lord.
Hmm.
One, Basavaraj has filed an impleading application. I
Hmm.
seek time to file objections to the same, my lord.
What about rectification of the office objections?
My lord, that they have to do, my lord. I am for the petitioner.
It is,
The copies have
26
not
is
been
an
served
appeal,
upon.
writ appeal.
Writ appeal, please, my lord. This pertains to deemed tenancy, my lord. My lord recollects.
Deemed,
Tenancy, my lord, deemed.
But the copy of the application has not been served upon.
please serve copies on everyone. Objections if any. And please comply with the office objections as well on your application. Yes, week's time. List after probably 2 weeks.
Request for a
Objections
short
if any
date.
in the meanwhile.
Please, my lord. I will file objections by then.
Request
My lord,
for-
any date is fixed, my lord? Is any date fixed, my lord? May
28/11.
28/11. Deeply obliged, your honor.
27, Ramesh KS.
For the respondent, my lord. Appearing
Yes.
for the respondent. my lord.
What is the situation?
My lord, the matter was referred to mediation in the month of
And
my lord, in June it was referred to mediation, my lord.
And respondent was directed to produce the latest salary certificate. And there is no point in conducting this appeal for the reason that the respondent had taken another lady in marriage even before. Very unfortunate case, my lords. I produced some material to indicate that he had.
have you
taken-
placed that on record?
Yes, yes, I have produced some material. I can't have direct evidence with regard to this marrying another lady, my lord. But he has produced the invitation card of 2022. And obviously it is a created and.
2022 was before the decree.
Yes, it's before.
My lord, that would be a
What
wrong
do you
submission
say?
to make. My lord, the decree of divorce, my lord, was
Hmm.
passed in the month of. My lord, the decree of divorce is dated 4/12/2021. My lord, I have filed the invitation card of my second marriage to this honorable court in my objections to the IA number 2 and 3. I have placed it on record. My lord, the date of marriage is 16/3/2022. That was
16?
16/3/2022, my lord.
Hmm.
I have produced the date of, I have produced the invitation card as well. My lord, here the,
Therefore, that is not the issue which is relevant now. Now the question is with regard to permanent element.
my
Is
lord,
that
with
right?
regard to, my lord, with regard to permanent alimony, my lord,
Hmm.
throughout the trial court proceedings, they don't seek one application, they don't make one application, not, they don't even seek the prayer of alimony. In fact, my lord, it's also on record in the evidence recorded
Hmm.
that they have, that the wife does not want any kind of alimony or maintenance and only she wants divorce is what she has stated in her evidence.
There are
And now, my
children in the
lord,
marriage?
no, my lord, there are no children in the marriage. And now, after the decree of divorce is
Yes,
granted,
we'll hear it on the merits. Are you ready?
My lord, I would seek some accommodation for arguments on merits, my lord. A week's time, my lord, for arguments on merits.
He is required to produce the salary.
Yes, where is the salary
has-
certificate?
My lord, I have produced it, my lord. It has been submitted. It has been
Where,
submitted.
when?
The latest salary certificate has been submitted to the court.
When has it been submitted?
My lord, that would be dated. My lord, it was submitted in open court on.
Is it not on record? It must be on record. Assets and liability statements are not on record.
No, my lord, it's not on record.
Both of them.
In fact, I tried to file the assets and liability statement, my lord, but then again, the assets and liabilities was not taken on record, and only the salary certificate was insisted upon by my learned friend.
Because they have objected to it.
Yes, my lord.
Yes.
My lord, I'm ready to file my fresh assets and liability statement.
Please place your assets and liabilities on record.
Kindly, my lord. I'll place it, my lord.
Yes.
Yes.
There's one to a false affidavit accompanying the assets and liabilities. I have filed counter to that also.
We'll consider it. Yes.
My lord, my lord, if is a date fixed, my lord, in this regard?
I think you have a very short date. I'm not going to conduct the appeal.
28.
There's no point in my arguing the appeal on merits.
28/11, too many matters are. Give someone.
29.
29.
Well, it is.
Kindly, my lord.
They make a note of this.
Yes.
Has taken legal.
Yes. Please record that the appellant is present in person. The learned counsel for the respondent seeks accommodation to argue the matter. List on 29/11.
Kindly, my lord. My lord, I may also be granted liberty to file my assets and liability statement, the latest ones, my lord.
The learned counsel for the respondent submits that latest assets and liability statement incorporating the matters which has been objected to in the earlier statement shall also be on record by then,
Kindly, my lord.
after serving a copy on the learned counsel for the appellant. Yes.
Kindly, my lord.
Hi, sir. Both of them arising out of the same judgment.
28. Sriram Timappa. Nayak.
Oh,
Serial number
yes, correct.
28.1 and 28.127. They are not connected to this matter.
28.1 is
127.
MFA 3278.
127. MFA 437.
Yes.
But I need 4 weeks time and an accommodation may be made. First 30 matters can be given to me in the next week so that I can at least comply. What is happening is whenever I'm writing some case numbers, some other files are coming up. So I'm not able to comply. I'm carrying the bulk files of some other papers and some other papers are coming up.
Just a moment. 28.127 is 4237 of 23.
Appear for the
Those are the two
respond-
matters which are not connected.
They are family court matters, my lords, arising out of the same
Yes,
judgment.
wheeling, appeal number, MFA number 3278 of 22 and
37, my lords,
4237
of 23, my lords.
of 23. From this list of matters and list according to roster.
Much
Yes.
obliged.
The other matters, what is the issue? Can I?
Lords, seal number 28, my lords,
Yes.
is ready for admission matters, my lord, because objections have been complied with, have been served, my lords. So I'm going to understand the 28.2 to 28.126, my lord. The very same question is involved, the very same appellant, my lords, and the very same respondents. Only the property numbers, my lords, are different. So the contentions also are the same. So I'm ready to be heard, my lords, in seal number 28, my lords.
Need some accommodation because all the matters together.
Just a moment, just a moment,
Also maybe.
just a moment. Please. This happens in the cooperative sector as well.
My lords, the question raised, my lords, is that once a society is registered under the provisions of Cooperative Societies Act, it will not come under the purview, my lords, of the KPIDFE Act, my lords, is the primary contention of the appellants. But that has already been settled by 2 division bench judgments of the Mumbai High Court, my lords, and 1 order of the learned single judge of our court, my lords. And the second contention of this is that I am a bank regulated by RBI, and hence it is only the RBI that can be a regulating authority. My lords, in terms of section 59 of the Act, my lords, they have not produced the license that is to be issued by the RBI for a body to be considered as a banking authority. In view of the same, my lord, the Honorable Special Court has categorically held that there being no documents produced to show that they are a banking company.
Just a moment, this is a primary credit society?
It is not, my lords.
It is not a primary
It
credit.
is not. So,
It is not an urban bank as either.
no, please, my lord.
Sri Canvas or the Credit Cooperative Limit. The registration, certificate of registration is available?
I can produce. Not only,
That would answer it, because if it's just a credit cooperative, it is not a bank.
What has happened is Sauharda Act is a entire complete act, because there is an arbitration also, everything can be done under Sauharda itself. And Sauharda has taken action, but what had happened under Sauharda, a particular individual was appointed to conduct elections. What that individual did, he superseded his powers, he closed down the entire branches of my society. Based on that, the complaints were filed. Then the state government got involved. As they only say, when a particular society, the Sauharda, which is also controlled by the state, when it has taken over the society, my society comes under the state government itself directly. There was no particular necessity for KPIDFA to be included and taken over with respect to
My lord,
all
this Hobbesian principle, every state permitted action is a state action, appears to be the contention, my lords. So I'll place my arguments and the judgments. But in fact, this argument, my lords, has been considered by the Honorable Special Court, which says the only method of regulation is not a control per se. Lords, in which case, my lord, every state permitted or recognized action would become a state action. So every private company, because it is incorporated, would become a state entity. It would have, my lords, far-reaching effects if this argument is to be accepted.
What has happened? The state government has proven its power over my society by
The
appointing an
state
individual.
government has superseded the committee and has appointed an
Based on
officer
Sauharda Act.
based on the
Yes,
yes,
Sauharda Act.
that can only be a power which is exercised in terms of the act.
Based on
And
that,
it
I
cannot,
think all the
if
properties are
all
on
the cooperative societies, where the managing committees are superseded by the state, and an officer of the state is appointed as the administrator on the basis of the provisions of the Cooperative Societies Act, can you say that all those societies are state? There are, the apex court has specifically answered the question that cooperative societies would not answer the requirement of state under Article 12. Under any circumstances,
Luckily, my lords,
not state.
it's no more a question of non-liquid, my lord. This very question has been answered, my lords, by the 2 benches of the Mumbai High Court, my lords, and 1 of our court. I'll place it on record for my lord's kind consideration, my lord.
all the properties have been attached by the again, same properties are attached by the KPID also. And then there is ED also which is coming in.
Let them raise objections. Enforcement direct, let my learned friend not carry a brief either for enforcement directorate or for Sauharda. They will carry their brief, my lord.
So based on that, I was pleading.
Question is simply this, is the attachment proper? That's all we need to. That is all we require to answer it. As simple as that.
May I make one humble prayer, my lords? Instead of, my lord, the incremental, my lords, posting of the matters, let 8 weeks be given to my learned friend. I understand the massive 127 matters. Since there is no interim order operating, I'm not, my lords, pressing for it. Let there be a peremptory order passed, my lord. As much time as my learned brother wants, and a peremptory order.
30 matters each week I will finish it. And the matter may be 1 to 30 first week, 30 to 31 to 60 next week.
There are quite a few matters and, just the work may be difficult otherwise. Yes. First 30 matters will be listed after 4 weeks. First 30 matters will be listed after 4 weeks. Then week on week, after which probably it may be, after the first 30,
Yes.
probably it may be a little easier.
Yes.
Once we decide the question, then it is only a matter of listing. And,
With my last permission, my lord. With my last permission, my lord. If seal number 28, my lords, is taken up, my lords, and if it is heard, my lord, the very same questions of law.
then it need not be, the others need not be listed separately is here.
Please, my lord.
But
For
then-
this reason, my lord, every time this batch of matters is listed, my lords, there's a liability on the state, my lords. That's the reason, my lords.
So what we'll do is we'll list one matter, this 20, can we list 28 on the first day? Immediately after 4 weeks, we can list 28.
Yes.
The questions of law, we can settle there.
Yes.
Everything else will probably have to be listed because in some of the matters, court fee is not paid. There are other issues involved.
Please.
So let us decide on 28. It is ready now for,
28 is ready, please, my lord.
yes, yes. Mm. 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 Yes, list 1 to 1/8 of 23, list after 4 weeks. Then once the questions are decided, we can
My lords,
proceed with the other matters.
please.
List only this after 4 weeks. Delink all the others, list only this on after 4 weeks. And if the question of law is decided here, the other matters can follow.
Please.
Notices. Yes, what is the office objection in this matter? Here is the case where, what is the office objection?
28, sir.
Yes,
1 to 1/8.
Yes.
Certified copy, Manoj, what has happened? There are connected several matters. I have produced certified copy in one of the matters.
certified copy dispensed with. Then anything else?
Memo is with respect to attaching all the other matters along with this matter.
That is, all the other matters are delinked, so that is also gone.
I served the copy.
Yes, copies have been served.
Sir,
That is
sir,
it.
please, my lord.
Yes. Yes, notice, so-and-so accepts notice for the competent authority, the learned government advocates accept notice for the other respondents. Any other private respondents to whom notice has to go? No. Yes.
Please.
So service is complete, list all.
In some matters, my lord, interim orders are operating, my lords. May I give the serial number, my lords, to the court officers so they cannot be posted in the first batch of matters, please, my lord.
Yes.
Obliged. me.
Twenty-nine, Ambikayam.
Yes. Just a moment, please. 128.1 and 128.127. Please remember to delink and list it separately. First file it is. Yes, please. Sorry. Paper publication has been taken. Yes.
Rukmini.
Mm. 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 Mm.
Does he appear before the trial court?
Karnataka was.
Kannada Prabha.
Yes. Notice has been duly taken out to the respondent by paper publication. The memo for acceptance of the paper publication is taken on record. The respondent notice to the respondent is therefore held sufficient. There is no appearance for the respondent. All doubt absent. Yes. Yes, what is the appeal? Are you ready in the matter? Do you want to post it? List after maybe 2 weeks. Yes. Admit list after, give a date, maybe after 3 weeks.
Already
Yes.
admitted.
Already. TCR bani.
12/6.
TCR bani.
3 weeks.
5/12. 30, Vani HV.
For compliance is last chance. Shall stand dismissed. It is already dismissed. This is on 5/12/23. And 25/3/24. Weeks 10 granted last month, that is also going up. No appearance. in Order. As order dated 5/12/2023 has worked itself out in view of the fact that the necessary has not been done even within a week from 25/3/2024. List after 3 weeks.
Thirty-one, Banu Prakash Viji. Weeks.
Weeks time.
32 urgent, 33, Sriram, Timappa Nayak.
See, for 2 weeks time, the matter is getting settled.
Weeks time.
34
Granted to comply.
urgent, 35, Madan KS.
4th time, what is this? What are the office objections? Weeks time. Shall we wait?
36, Court fee provision to be stated below.
Week stay. Yes. Week's time is last chance. If fourth time matters where nobody is appearing, week's time is last chance.
34, 35, 36.
In one case, somebody appeared. 34, 30, 33, give some time. 34, 35, 36, last chance.
37, Shilpa.
Milord, I appear for the appellant.
Yes.
In this matter, Milord, cause list shows that furnishing of EPF cover, etc. For that, Milord, we have already served copy to government advocate and we have filed a memo along with acknowledgement on 18th September 2024, Milord.
R4, R5.
Yes, Milord. Yes, Milord.
To accept notice, government advocate.
We have served copy and we have filed. Yes.
Memorandum of MFA. R4 is SLAO and the executive engineer.
Yes.
Yes, please. Copy has been served. They say it is memo. Yes.
Yes. And Milord, so far as Milord, one more, Milord,
Hmm.
non-filing for acknowledgement for having deposited amount. Milord, yes, Milord, we have, I mean, there is some delay on our part due to Milord some administrative reason. I request for Milord 3 more days, Milord, to deposit the amount, Milord.
Yes, it is submitted that the learned government advocate has been served for R4 and R5. And that copies have also been served. The remaining office objection with regard to deposit of the 50% of the award amount will be complied with within a week.
I'm highly obliged, highly obliged.
38,
My lord, I appear for the appellant.
My lord, I am appealing for respondent, my lord. I am appealing for respondent. I seek a short accommodation to file my objections, my lord.
What about IA 1 of 24?
IA 1 of 24 is the one, my lord, which he wants to file objections. Y of
But
1 of
there is
24 is in
some
respect of stay of the
There are office objections on IA number 1 of 24.
IA number
Please
1,
clear
my
them.
lord. The one is regarding Karnataka Kannada translation because the petition for restriction of conjugal rights, my lord, is in Kannada. That I will furnish, my lord, in the meanwhile.
Yes.
Yes, my learned friend has sought for stay of the MC petition, which I have filed for restitution of conjugal rights, and he has also filed for stay of criminal petition, which I have filed invoking the provisions of Domestic Violence Act. So I pray for short accommodation, my lord, to file my objection.
Yes. Learned counsel for the respondent seeks time to file objections. List after a week.
Yes.
Because
2 weeks.
I have to get the records from Ranebenu, where the from the trial court judge.
2 weeks.
Let him not precipitate the matter, my lord. The matter is registered tomorrow.
Yes, please don't precipitate the matter.
I will not precipitate, my lord. I will ask the council to take time.
Yes.
Obviously.
Your lordship, kindly fix a date.
It is submitted, the learned counsel for the appellant submits that the office objections in IA 1 of 2024 will be complied with immediately. The learned counsel for the respondent seeks a short accommodation to file objections. List after 2 weeks. In the meanwhile, it is submitted that further proceedings will not be precipitated before the family court. Yes, list after 2 weeks.
Thirty-nine adjourned. 40, Harsha Kumar Gowda.
Two weeks' time to comply
41.
with the office objections.
Arvind Reddy.
Appearing for responding matters. Yes, what is the office objection? Copy is served. Please, you've received. Yes, ma'am. Yes, it is submitted that copy of the appeal has been served on the learned counsel appearing for the respondent. A week's time is sought for to comply with the remaining office objections. List. Much obliged.
42. Devi Hiremat.
My lords,
Yes.
Here, PA number 6 and 7 are filed by the by petition number 13 to 15. So that it's for this reason they where one medical college was closed. Yes, medical college. And by virtue of this, there are some colleges. Now the question was, what is the fees to be paid? The students say that whatever the fee that is paid, but fees fixed by the MC has to be paid. But in this case, the fees whichever my lord that the closed college has demanded, of course, that fee has to be paid was the demand. That has been challenged. In the meanwhile, my lord, some of the students, my lord, approached Ambedkar College. They said we are ready to accommodate you in our college.
Provided you pay the notified fees.
Okay. Whatever the fees actually notified. Therefore, because we can't pay the exorbitant fees, my double fees. And therefore, my lord, these applications of 6 and 7 are filed by some students, my lord. For that, seeking permission. On identical circumstances, this on code is allowed.
6 and 7 can be allowed. Nobody has any objections to that.
No, insofar as that aspect is concerned, we have not received the copy, my lord, sir. I am appearing only for one college, my lord, sir. Insofar as my college is concerned, they are not claiming.
6 and 7 is not there. No problem there. Yes, just a moment. IA number 6 and 7 in 42.
Yes, sir.
6 and 7.
Mostly.
Number 6, my lord, to include Ambedkar College. One IA is my lord seeking permission to admission to Ambedkar College. On the ground that Ambedkar College has also agreed, my lord, for the admission.
Yeah, to the admission, everybody is agreed. It is the fees that is the problem. Formalize the admissions of 1, 2, 8, 10, 11, 12, 16 to enable them to appear for the second year.
Not that.
That is IA 7. That is IA 7.
Okay, last IA is my lord, please, my lord. IA number, I beg to submit 6 and 7, my lord.
7, this is the prayer. I just read out the prayer in IA 7.
No, if they implead one of the college, my lord, sir, we can't object for that. I appear for respond number 8.
8. No relief.
Yes, IA number 6 is also not for impleading. IA is to direct the 5th respondent.
my lords, kindly
University
pass
to
on my
issue exam.
That's not. May from beside permission.
Just a moment. Let us look into these for retirement for.
That my lord, where is my lord? The name of the retired advocate. My lord.
Date of application. Date of application.
Date of application 27 September.
IA for impleading 27/9. That is IA number 5. PR Ambedkar Medical College and Hospital as respondent number 20.
21.
Yes.
I think it is 21. Man. 20 is BGS Global Institute.
You are not kindly permit us to make it as 21.
Please make the correction so that we don't go wrong again.
As per my copy.
Yes,
20
please carry it out. And please carry out in all the copies as well. It has to be done simultaneously, otherwise it will create further problems. The idea is to be corrected. Just to be 21. 20 is already there.
20 is there, BGS Global Institute of Medical Sciences.
So make this 21.
As per my copy, it's available.
Please verify and do the necessary so that when do you want it listed? We don't want to create a confusion. They'll have to be, I mean, now you have to take out notice to them, they have to be served, they have to come, and they have to say what have their say in the matter. Are we right?
My lords, can I mention, my lords? My lords, exam,
Yes, what do you say?
my lords, kindly pass on. My senior colleague is in other court, all my lords. Exams are very near, my lords. Kindly pass on.
Please do that once we started. We are not otherwise convenient. Kindly follow. Next matter also.
Same.
Same matter.
Insofar as examination is concerned, my lords, previous order, it directs direct all the institutions not to disturb the appearance in the examination, my lords. Previous order is there, my lords.
Can we see the order sheets, please?
Because all this dispute with regard to fee structure is concerned, it has to be decided on the basis of the submissions of respondent number 3, my lords. Director of Medical Education.
Yes, just a moment. 10?
10/7/2024.
Yes.
Dispute was further considered in pursuant para 2, my lord.
Mm.
Para 3.
Mm.
All frame the petition is set aside the communication dated 2/2024 issued by respondent number 6.
Mm.
Insist the petitioner to make payment of higher amount towards fees as management quota in respect of subsequent year MBBS course in which the petitioner has been studying.
Mm.
Case the petition is that while he is getting admission to the course,
Mm.
they were paid 15 lakhs 11,950 and different amount in other case as evidence of the specific he received. Produced on record. It was the case that the fee structure was not made known to them at that time. The petitioners were given to understand the same fee will be the fees. The case that the same fee will require to be paid by them for subsequent year. It was stated by letter told editor petitioner that the same amount has already been deposited towards fees from subsequent year course of MBBS and is accepted by the college. On the other hand, the editor for NMC. When the fees were notified, however, there is a bungling between KE and DME. The fee structure produced is reflected in the letter dated 19/3/2024 with the communication of subsequent date. The petitioner was admitted on 28/12/2022 and 29/12/2022 to be thrashed out as to whether the petitioners were made aware about the fee structure at that point of time. Fee receipt does not indicate fees charged was towards partial payment. With that only on account of some bungling between KE and office of the DFD regarding KE charging of fees. The petitioners who are already admitted and have been studying the course should not suffer. In that view, prima facie case is made out. There shall be rule returnable on so by printing. Petitioner shall be permitted to attend the classes for the second year. MBBS course shall be permitted to appear in the ongoing as well as with the internal and theoretical examination. Later, the permission grants to appear examination attend the classes cannot be iniquity.
Therefore, there is already an order that you will be permitted to.
Yes.
Yes, what happened? What is?
They are not, colleges are allowing them, though there is, the students are affected in classes, they have not taken the admission also formally. And they have not even forwarded their names to the colleges now. And they are not even allowing them to now pay fees for exam, because the last day this month.
Which is the college which is not permitting this?
No, insofar as
Colleges were there participating in the relocation counseling. The counseling was held on 30th of September 2022. On that day, none of the colleges have made known to these petitioners how much they should be paid. And in the first order of the beginning, they clearly in the petition below.
What does it say with regard the notified fees?
From the students, it was notified to the students by the six respondents here in the college, which is the health college. Now they say, turn around and say, you take the notified fee. Because they will not make more, at least at that time, they would have moved to mathematics. They were not, they were kept in that. Suddenly, the DME turns around and says, you have to take the fee, which was notified by the TE in the.
No, anyway, now the issue is the present issue is with regard to taking of the examinations. This order clarifies that permission granted to petitioner to attend classes shall not create any equity, etc. Petitioners shall be permitted, by way of interim relief, petitioners shall be permitted to attend the classes of the second year MBBS course and shall be permitted to appear in the ongoing as well as future internal and periodical exam. If in any case it is not done, it has to be placed on record. If that is your contention, if any college is not permitting you, where? Where do you say? No, pay the fee is another matter. If they have not been permitted to attend classes, or where do you say so?
They're not unofficially, they're allowing.
Which college has not permitted you to take the examination? Please show us.
Colleges, correspondence having to remain in colleges have not allowed them to pay.
Where do you say so? Which is the IA? 6. Yes.
It is necessary to formalize it.
Still don't get any of this. Where? Copy of notification and formalize the admissions, so and so. Where do you say that you are not being permitted to take the examinations?
However, the petitions are not being given formal admission in their respective colleges. It is a notification basis, secondary exams have been issued.
Yes, what is the situation now?
No, insofar as that aspect is concerned, my lords, insofar as issuance of hall ticket and other things, respond number 5 will have to answer, my lords, because university will have to issue that, my lords.
Who appears with the university?
And insofar as fee structure is concerned, respond number 3, Director of
Fee
Medical
structure we'll
Education.
consider.
Yes.
As of now, the
That
urgency
they
is
will
with
have to
regard
answer.
attending the classes and writing the
Yes, my
examinations.
lords. Yes.
Yes.
Insofar as IA number 6 and 7, I have not received the copy also, my lords. Without that copy, I am submitting, my lords.
My letter is appearing only for one institute.
Yes.
Only for one institute.
No, whoever that be,
Please.
the
They are
copies
making
have to be served so that, please serve the copies so that they can
Please.
revert on this matter if there is any requirement. Where is the fifth respondent?
They have to-
University.
Girish Kumar.
Pass over.
Please.
Pass over,
Please,
2:30.
And now it's at my lord, it is very next matter, sir. Very next matter.
Hmm.
Take a student, my lord.
Hmm.
Student got permission to be admitted to Ambedkar.
Sorry?
To Ambedkar College.
Yes,
And Ambedkar College said, we have no objection.
yes.
This one is directed
Hmm.
that Ambedkar College be implemented.
Hmm.
Ambedkar has been implemented in the present case, my lord. And she has been attending Ambedkar College because Ambedkar College, we have no objection. And the last opportunity, my lords, and last hearing.
Impleading allowed, notice taken to Ambedkar?
Please, that's done. Served.
Served also.
Served, because they have given it in writing, my lord. That the document they have given in writing stating that they have no objection. That's already produced before the honorable court. Annexure D. By annexure D, in writing they said we have no objection.
KE and the university, they have to be here.
Yes.
2:30, let's see.
So my prayer is, same prayer as made in this petition, my lord. the present one which is before my lord. Same prayer is made by 3 applicants therein. Respondent number 13, 14, 15 in the previous case. 13, 14, 15, same prayer. That they also wish to be shifted to Ambedkar. Ambedkar has given in writing. So same Ambedkar, because even when notified my lord, they have not appeared because they have not, they have given in writing. Let us hear.
Which is the, you've produced it with a memo?
Yes, yes. Next T in the previous case.
An extra T.
Oh, please. In the previous case.
Yes. Pass over.
Please. The problem is, my lord, without the fees, Ambedkar will not admit. That's all. To that point, there is already interim order by this one. Great.
Yes.
Final hearings number 44. 45.
Passed over may not be possible today because after lunch there are these specifically posted matters. We can have it on a near date. 44. 47 is a parted matter. We may be taking that up. Yes. Yes, 44 and 45, please give dates. 45 is?
That is with regard to the, it's a parted matter, my lord. It's with regard to that Inams Abolition Act. Lordship was pleased to hear the matter.
Next Monday,
This,
can it be on a near date?
if this court is pleased to kindly have it on the 15th, please, my lord. Learned Senior Counsel submitted in this matter.
Yeah, 19th.
My lord, in fact, your lordship was pleased to hear for almost half a day in this matter. One more ploy they have applied.
15th we cannot accommodate, we're sorry.
Or a Friday, some Friday, my lord.
Give a date.
Next, succeeding Friday, my lord. 22nd, my lord.
Recall, their contention is that it is a vacant land and therefore I've been able to now locate certain.
My lord,
29th.
22nd, please. 22nd, please.
I want some time.
My lord, relying upon a 90th, first time is coming up with something.
Yes.
26.
Please don't make submissions when a matter is being listed, counsel. Yes.
22nd. Persuade your lordship.
29th, let him be ready. Instead of giving a listing and then making an adjournment. 29th.
Meanwhile, one submission, my lord.
Yes.
Learned Counsel appearing for one of the appellants in 1750 has served me with a copy with regard to substituting the, this is, I have no objection for it.
Yes. Memos on record, the learned counsel.
And my lord,
Appellant submits that there are no objections.
I'm sorry, my lord, one more submission in this.
Yes.
In writ appeal 976 of 2018, the
Just a
name,
moment, counsel, who has expired?
the LR of first appellant,
Yes, the
1750.
of the first appellant are permitted.
Time for the respondent.
Respondent, learned counsel for the respondent has no objections. That is in which appeal?
1750,
Yes.
lordship, in writ appeal 976 of 2018, the name of Mr. V. Karthik may kindly be deleted, my lord.
Yes.
It was an NOC.
Please do the need.
And also in writ appeal 3220, it says MA for R5, Wakalat not filed. Somebody else has filed that, may kindly be deleted.
Yes. Please delete the names.
Obliged.
Yes.
Obliged.
Yes, what do you want? Only if there is time. List it on some other day. Yes.
46, Basaraj T. 47, Shubhananti.
Please, your lordships. I'm sorry,
Yes.
my lord, I'm not able to come physically. I may
Yes,
address
yes.
the. Please,
Definitely.
your lordships. My lord, we were referring to the award of the labor court, paragraph 24.
Yes.
My lord, the last 5 lines of that paragraph. The witness at page number 15 states that he was collecting the amount from the second party, including the salary of workmen, allowances like PF, ESA, leave, bonus, and others. In that case, it is evident the second party was paying the salary. But if the contractor he collects the money of the expenses involved in the matter of supplying contract labor, and he charges the commission of 10% or whatever it is, and it is paid to him. That the labor court says, no, that itself shows you are collecting money on behalf of from the principal employer, they are the employees of the principal employer. That finding may not follow from these documents when he says first party to the workman. Even we believe that amount was paid to W. So that is a very clear finding that the contractor cannot supply a labor without any commission. He doesn't render free service to man. In fact, Lord, exhibit M1 and M2, if your lordship has a look at it, the company called for when he submitted for registration, license for our registration, we wanted to know who are his clients. Just because I can't employ somebody who is a wayfarer or a man of straw, as LB Supreme Court. So he supplies the name of the companies for whom he is supplying contract labor. That your lordships, therefore, my submission to lordships is that he is not a person who is just a make-believe or somebody who is a agent who just supplies labor and goes and makes money. He is in regular business of supplying contract labor for companies.
Yes.
In fact, that exhibit, my lord, if
Yes.
says is several companies of some repute in Bangalore to whom he is supplying, including the central government establishments. He is a contractor for about 62 companies. Therefore, people's choice, that is the career services. Now, my lord, the next paragraph 25. MW3 Prakash Bayer, who was working as security officer of Unique Security Services, he is the chief examination, almost deposed what is said by witness as to first party being not employed by the second party, but they are employed by security agency. He further speaks as to the production of documents 51 to 79. The witness has stated that he joined Unique Detective Agency in 5/10/2005. This itself shows that this witness does not know what happened to earlier to 5,000. Earlier to 5,005, my lord, the only relevant period, my lord, from the order of reference, we'll have to see when these people joined. In the, my lord, I submitted a document to your lordship, the suit filed in the civil court. OS number 242. Last occasion when I was addressing
Yes.
your lordships. Exhibit M22.
Yes.
That suit plaintiff, my lord, in paragraph 6. What the union which filed the suit. It says, when that being the fact, the plaintiff union came to know that the license of defendant number 1 is not renewed in 1994. After 1994, it is submitted the plaintiff union made a several representative second part labor department asking for direction to contractor for getting license renewed. It is submitted, it is not out of place to mention here that the plaintiff union came to know that this aspect of non-renewal license only in 1996. though they are continuously working under the said contractor since from 1992. Your Lordship, okay, this is the admission in the plaint. Therefore, the question of there being no record or license prior to 1990 or 89 is irrelevant. Why I am saying this is because in the labor code, a submission was made on behalf of the workman, of the contractor, that the license, because the factory started 89. Therefore, they have not produced any record, their license. Therefore, they are our employees are direct employees of the company. My submission to your lordships is that the submission is wrong because we have to go by the order of reference, which gives the name of the employee's employment from 1992. Only one person was in 1990 who from the earlier contractor who remained and worked under the subsequent contractor.
Yes.
In that aspect, my lord, if I may kindly request your lordship's attention to paragraph 8 of our counter statement, pleadings.
Claim statement.
Claim statement, para 8 of the claim statement. Before the Labour Court, page number 208 of volume 1.
208.
Yes, my lord.
Yes.
It is no doubt true that the second party
Just a
management.
moment. Just a moment, please. Let me just 208.
Yes, my lord.
Yes.
It is no doubt true that the
Yes.
second party management has used and continues to use certain methods or means to exploit workmen. It is not necessary to repeat what has already been stated regarding conditions of service of the first party workmen and the ways that are being paid to them. It was contended by the second party management on its in its statement filed with the Assistant Labour Commissioner that the management has engaged Messrs. Terrier Security Systems and they were providing service to Myco at Naganathpura plant with effect from 8th July 1992. And that contract was renewed from time to time.
Correct.
In the claim statement.
Correct. Further, that is the contention was that there was a contract, but that is a sham contract because the contractor did not have the necessary
Sham
license.
contract, I'll come to that as per the matter.
Yes,
Your
that is
Lordship.
the contention because the next sentence
Sir,
says
what would
whatever
be
may
sham
be the
contract if I am
position.
doing the Supreme Court as well as the full bench of this court have held full bench of this court in sales case, which I'll place it before your lordships, has held the consequences of not having a license or registration does not automatically confer the right of permanency or regularization for contract labor.
Shall we go to
That
that
is the law
judgment?
declared.
Shall we go to that judgment?
Wait a minute. That judgment, your lordship, kindly see, my lord, is sale, full bench judgment. My lord, compilation number 2 of list of citations. Compilation, that is, I produced from the factories journal reports, not the ILR. Page, my lord, this compilation number 2, my lord.
Just a minute.
This is the full bench judgment. Dated September 27, 1991. In that, my lord, I will take straight away, take your lordship to the observations of the full bench. That is the direction of the full bench. On the question referred, paragraph 9, it may be actually significant for your lordship's consideration. The bar, para 9 of that. Do my lord have it, my lord? I have not paginated the citations. Para 9. I'm sorry, but paragraphs are not numbered, I'm very sorry. Internal page number 162 of the judgment. Internal page number 162 of the judgment, my lord.
This is Supreme Court.
Sale workers, sale contract workers union. It's a FJR report, Factory Journal Reports.
Just a moment, which is the decision you're referring to?
I'm referring to the second compilation, that is Steel Authority of India Limited versus Steel Authority of India Limited Contract Workers Union.
Reported in?
Full bench. Second judgment in the compilation.
Yes. Yes.
In that, my lord, page 162, internal page 162, my lord, of the report. The judgment starts at 149. Internal page 162, the second paragraph.
Yes.
The bar imposed on the principal employer is found only in section 9. According to it, he shall not employ contract labor without registering under section 7. The registration under section 7 satisfies the requirement and removes the registration restriction against employing contract labor. Nowhere section 9 says that the employment of contract labor has to be the employment of workman through licensed contractor. Therefore, it will be unreasonable to attribute contravention of the relevant portion of the Act by the principal employer only because contractor has failed to obtain a license under section 12. When the law of nowhere prohibits engagement of non-licensed contractor for the purpose of employing contract labor, the eye of the law cannot ignore the existence of this contractor if engaged and registered by principal employer. The agreement between the principal employer and non-licensed contractor being not prohibited, it cannot be ignored as a void transaction. Then, my lord, they consider various judgments and all that. The operative portion and the ruling issues on the issues are at page number 174 of the internal page 174, my lord.
Yes.
Various reasons are given for their judgments. The findings of the full bench will be at page 174. Before concluding, we may summarize our conclusions as follows. The system of contract labor has not been abolished altogether. In the absence of a notification under section 10 of the Act, abolishing the system in question in a particular establishment, recourse to that system has to be inferred as necessary by that establishment. Whenever there is no prohibition notified under section 10 of the Act, the employment of contract labor cannot be treated as opposed to public policy. Neither the registration under section 7 nor the licensing under section 12 of the Act creates any privilege to employ contract labor. The purpose of licensing is regulatory in character of a right which is already recognized. It is impermissible to read into the definition of contractor under the Act as the holder of a valid license under the Act. The employer is not responsible for the failure of the contractor to obtain license under section 12 of the Act. There is no compulsion imposed upon him under that he should continue to engage only a licensed contractor. The statutory consequence has to be specifically found in the very statute. The very effect of contravention of any provisions of the Act is to be located from the various provisions of the Act, and it is not possible to infer a consequence which may result in imposing higher burdens or larger liabilities on a person who is not directly connected with the contraction with the law, as the case was the registrar of establishment engaged a contractor who in turn fails to obtain license. There is absolutely no warrant to deem a direct relationship of employer and employee between the principal employer and the contract labor only because the contractor fails to obtain a license, and such deeming will result in enlarging the scope of penal procedures without any express words to that effect. Regulation of contract labor, whether employed through a licensed contractor or through unlicensed contractor, is not one of the objects stated in the Act. The appellant is in this case complied with the provisions of Section 7. Finding to the contract labor court was rightly reversed by a single judge. Our answer to the question referred to in the consideration is that failure of the contractor to obtain a license under Section 12 of the Act would not result in bringing about a direct relationship of employer and employee between the contract labor and the principal employer. Now, this is a full bench judgment which was referred to in our submissions before the Labour Court, and also with a judgment of a single judge following this full bench also was cited. That judgment is in the compilation at page number of my list of authorities, my lord. It is Tumkur Power Karmikara, that is compilation number 9.
Yes.
So, my lord, maybe the Labour Court found it very difficult to get over this judgment to the full bench. But it should refer and abide by it. It should not simply ignore it and then say, no, you are receiving money from my principal employer. In spite of the contract, I have let in evidence to show everything, even the roster, register, supervision, everything was being done by the contractor. All this is ignored. This is approved by the Supreme Court in the Constitutional Bench, 2001 Waterfront Workers case. Vide para 131 of the judgment. Because the Karnataka High Court took a view by Justice Lordship Muller, the late Mr. Justice P.P. Bopanna. He said, Muller, the non-having a license would result in the contract level being permanent employees of the company, following Western Compton's case of Madras High Court. In fact, Kerala High Court also has taken a similar view. But unfortunately, today, the question is answered with Supreme Court by Constitutional Bench and the full bench of this court. The Labour Court is bound by the full bench, also the single judge. Both of them, do not consider that submission. Admittedly, assuming everything against me, that the contractor's license was not there from 92 to 94 or 95 to 94 to 97, not renewed by the government, kept for 2 years. I applied as well. My lord was pleased to point out, you yourself applied 1 year later. All these things will have not resulted, one thing, my lords may kindly be pleased to know that no unemployment has resulted by virtue of this. They have been continuously employed and engaged. And one more aspect of the matter is this, my lord. They are getting more salary than the other contract labor by virtue of the order of this court and the interim relief granted by the Labour Court. And they are continuing to do so even today. Much more than the minimum wages prescribed by the government under the Minimum Wages Act. Security services, the security guard, the highest salary is about 19,000. Here it is more. My submission to Lordship is, the question is also answered by the Supreme Court in Denanath's case, which is compilation number 3, 1992 1 LLJ. Para 20 of the judgment.
That is, yes, 92-1 LLJ.
Sorry,
Is that
ma'am.
right? 92-1 LLJ.
Yes, my lord. That is
Yes.
compilation number.
Is citation
Three,
number
my
3.
lord. Compilation number
Citation
3.
number 3, you mean?
Yes.
Hmm.
There. Where are 20, my lord, they answer the question.
Para?
20. After referring to various judgments, though they are talking about Article 226, the proposition of law seems to be the same as submitted by me.
Hmm.
It is not for the High Court to inquire into the question and decide whether employment or conflict labor in any process, operation, or any work in the establishment should be abolished or not. It's a matter for the decision of the government after considering the matter required and considered under Section 10 of the Act. The only consequence provided in the Act and whether the principal employer labor contractor violates the provisions of the 9 and 12, respectively, the penal provisions as envisaged under the Act, for which reference may be made to Section 25 of the Act. We are thus of the firm view in a proceeding under 226 of the Constitution merely because the contractor or the employer violated any provisions of the Act or the rules, the court would not issue a mandamus for deeming the contract labor as having become the employees of the principal employer. Therefore, even under 226, the Supreme Court says the court may not exercise that kind of a. In the very same judgment, that is with the constitutional judgment, Sale, my lord, which is the authority on the point, that is compilation number 7. Compilation number 6, my lord. Compilation number 6. Madam? This is, my lord,
Compilation 11.
no, compilation number
11.
11, my lord. I'm very sorry. No,
Completion is the same. You mean citation number
compilation
11.
number 11, my lord.
Citation 11,
Yes, my lord. Yes, ma'am. Sorry, my lord.
which is
Citation
the,
number 11.
which is
Your
the,
lordship is right. Steel
which is the
Authority of
citation?
India and others versus National Union, Waterfront Workers, and others. My lord, this is the relevant paragraphs may be, my lord, 91, 90, 91, 113, 114, and 119.
99.
Your lordship is straight away go to page 1, paragraph 119 of the report. What is the consequence?
Okay, 99, sir.
Okay. 119, my lord. The upshot of the whole discussion is outlined thus. At page number, internal page of the report 1131. Do my lordships have?
just a moment, please.
Traditions is the Silpa Gilwa.
There are 99.
Oh, English is the man.
The same provision, like they don't become.
Yes, please give us the citation, please. We'll get the decisions.
My lord,
Because there is no
citation number
pagination.
11, my lord. Sale versus National Union Waterfront Workers.
Hmm.
If you are not page it, do Mali or flag. If you flag it, you are.
Hmm.
I'm sorry, Lord, do my Lord serve it, Lord.
Yes, we got it.
Lord, the upshot of the above discussion is outlined this. They decide about the who is the appropriate government, etc., in respect of that. Then, my Lord, the note, then second paragraph. A notification under section 10 of the CLRA Act prohibiting employment of contractor activity in any process, operation, or work in any establishment has to be issued by the appropriate government after consulting the board, control board, etc. Conditions of work, benefits and provides also. Then your also may come to para 3, subpara 3. Neither section 10 of the CLRA Act nor any other portion of the Act, whether expressly or necessary implication, provides for automatic absorption of contract labor on issuing a notification by a private government under subsection 1 of section 10, prohibiting employment of contract labor in any process, operation, or other work in the establishment. Consequently, principal employer cannot be required to order absorption of contract labor working in the concerned establishment. We overrule the judgment of this court in Air India's case prospectively and declare that any direction issued by any industrial adjudication or court
Hmm. Yes.
for absorption of contract labor following the judgment of Air India shall not be set aside, altered or modified on the basis of judgment in cases where such a direction has been given effect and is also become final.
Hmm.
Then, my Lord, on issuance of notification under subsection 1, section 10 of the Contract Labor Regulation Act, prohibiting employment of contract labor or otherwise in an industrial dispute brought before it by the contract labor in regard to condition of service, the industrial adjudicate will have to consider the question whether the contractor has been interposed, either on the ground of having undertaken to produce a given result for the establishment or for supply of contract labor for the establishment under the genuine contract, or is a mere use camouflage to evade compliance of various beneficial legislations. Lord, I have let in evidence here to show all the beneficial legislations have been complied with. ESI Act, Provident Fund Act, bonus, gratuity, everything is complied with. Leave on festival holidays, the holiday wages, everything has been complied with. It's not a camouflage. It's a genuine engagement of contractor who has been engaging this contract labor for a long time. Therefore, my submission to your Lordship is, the Labour Court, my Lord, could not have ignored the judgment of the Supreme Court in Constitution bench, and also the single judge following the same in Tumukur Paru case, and my Lord, hold merely because the license was not renewed for a certain period by one contractor. My bona fides are shown because I terminated that contract saying, if you don't want to go away, I don't want to engage you. Therefore, I recruited Godwell in the place of Treasury Secretary. And all of them were continued in the same employment by giving applications to the contractor by the exhibit
34-1 to 76.
34, exhibit number 34-1 to
M34-1.
M34-1 to
76.
76, my Lord.
Yes.
They gave an application. That is also marked before the Labour Court.
Biodata.
The biodata they gave to the subsequent contractor.
Yes.
Now, your Lordship may kindly see, they went to the civil court for a declaration that we are the contractor, they should not be terminated, even though the suit was not pursued. Nobody was terminated from the services. They all continued. In fact, in this factory, my Lord, I may
The
say.
prayer in the suit was not as against you. It was that the subsequent contractor should not terminate them, that they should be.
No, I am a third
continued to
defendant.
be employed.
I am a third defendant. No
You
relief
are the
against.
third defendant, but it is not against you.
No.
Yes.
No.
Yes.
That is not against me, but only thing is, I was made a third defendant.
Yes.
To show perhaps I am the principal employer that I should not interfere with their right to
Yes.
continue employment.
Yes.
What has happened now with these things, Lord? I would submit the labor court having found that the union
Yes.
had no locus standi to raise a dispute. May not be, therefore, we could not have entertained the matter at all.
Yes.
My Lord, the labor court found on the preliminary issue that the dispute is not, no locus standi to raise a dispute. But nevertheless, there is a community of interest among themselves. That is not what contemplated by the court, because even Dharamchand Dharampal case, my learned friend would cite, there was no union of the company for the principal employer,
Yes.
workman. Here there is a union, admitted fact. And why the labor court did not consider this suit plaintiff lord was, even though admitted in cross-examination by Shivashankar that the suit is correct, this is the plaintiff, this is the prayer, the court rejects it on the ground it is not a certified copy.
Yes.
That was being produced, certified copy subsequently produced, of course. It is exhibit M100. M100. Why I am saying is, even though 6 rules of evidence do not apply to these proceedings as held by the Supreme Court in Union of India versus Verma in 1959 itself, the court rejects the plaintiff, saying it's a certificate, not a certificate copy. My Lord, then since the Air India has been overruled, specifically by Supreme Court Constitutional Bench,
Yes.
my submission is the observation of in Air India overruling Gujarat Legislative Board would not be correct. Therefore, Gujarat Legislative Board principles would still apply. That is, my Lord, your Lordship will kindly see, 1995, in the compilation, I produced a judgment.
Yes.
My Lord, Gujarat Legislative Board is compilation number 5. Citation of judgment.
1995.
I am just giving. 1995, 2 LLJ.
Page 790.
Page 790.
Yes.
Compilation number 5.
Yes. Can we hear the respondent now? We'll come back to you after the respondent's arguments are over.
Your Lordship wants to hear the respondents now.
Yes. Are we not through? We'll hear the respondents and then we can hear you in reply as well.
But one thing before your Lordship does it, one
Yes.
small submission. I thought I would show you, your Lordship, the evidence on record. What documents have been produced with regard to supervision, payment of salary.
Let us go into that if required.
Very well.
Please let us hear the respondents and if it's a question of law, we don't, even otherwise, the writ court is not expected to look into the evidence on record and reappraise.
No, only to show perversity of the approach.
Absolutely, absolutely. So let us hear the other side. And if it is required, we'll hear you on further on the.
As your Lordship.
My Lord, just before you start, can we continue probably after lunch? Because there is a 1:45 meeting that I have to attend in the City Civil Court. It may not be possible if we leave it too late. Okay.
At 2:30, my lords?
Yes.
Very well.
What happens is otherwise it might, we'll have to truncate the arguments.
Please.
Let's start immediately after.
Very well.
May I submit that?
Yes.
Serial number 50, my lord.
Yes.
May I request for a next week, my lord?
Yes. Who appears against you?
My lord, I represent the appellant in this matter, my lord.
There is an IA to vacate the interim order.
Yes,
Yes.
true, my lord. After hearing only, interim order came to be granted.
You can list it on.
I appear for respondent in this matter, my lord.
Yes.
We have filed an application for vacating of an interim order.
Can it be to another near date? Because it is not likely that it may be taken up today. We have 3 or
Can we
4
take
130 matters. I mean, 230
Can we
matters.
take a chance post lunch, ma'am?
Next week, my lord.
There is
Post-lunch,
an,
there is no chance, which is why we are saying this. Otherwise, there was no difficulty.
My lord, with.
possibly in this week, my lord.
Serial number 49, my lord.
Could it be next week, my lord?
Just a moment. Yes,
Next week, any convenient date of the court, my lord?
20th, 2011.
Please, my lord.
May I please, lordships?
My lord.
May I please, lordships?
Yes,
Item 51, my lord.
yes.
We need to file the translations. Some 2 weeks time, my lord.
My lord, serial number 49, my lord.
Hmm.
Kindly have it in next week, my lord.
It's, I appear, I was original petitioner, no objection. My lord. If I may, my lords may recall, this were state and BDAs in appeal. State, the police station, they wanted to allot the land, but my lords, it was directed to be.
Is already.
Yes, my lords, and
there
there was
to-
already on 31/10, there was instructions to the state government also to say, and my lords, at 2:30, my lords, earlier it was being listed at 2:30. On the last date of hearing, because.
We'll see. All matters 230, we cannot list it on some other day. Yes.
Serial number 51, if a date may be specified.
212 can be. 212.
Court officer. Madam.
20ನೇ ತಾರೀಕು.
Madam, serial number 49 ಅರ್ಜೆಂಟ್ ಆಗಿದೆ.
ಟ್ರಯಲ್ ಕಟ್ಟಿಗೆ ಏನು ಹೋಗಿಲ್ಲ ಅನ್ಸುತ್ತೆ, ಏನು ಹೇಳಲಿಲ್ಲ.
ಯಾವತ್ತಿಗೆ ಅರ್ಜೆಂಟ್ ಆಗಿದೆ ಮೇಡಮ್? ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ನಾನು ಸೀದಾ ಆಫೀಸಿಗೆ ಬರ್ತೀನಿ.
serial number 49.
ಸರಿ, ಬಂದ್ಬಿಡು.
ಕೋರ್ಟ್ ಆಫೀಸರ್.
3/12 ಸರ್,
next week
49.
ಆಗಲ್ವಾ?
ಓಕೆ.
ಸಾರಿ, ಬೈ ಮಿಸ್ಟೇಕ್ ನಿಮ್ಗೆ ಬಂದಿದೆ. ಏನಂತ? ಏನಂತೆ? ಅಲ್ಲಪ್ಪ, ಜಿಸ್ಟ್ ಆಫ್ ದಿ ನೋಟಿಸ್ ಏನಂತ ಮಾಡಪ್ಪ, ತಾಕತ್ತಿದ್ರೆ ಬಾಲ್. ಕೊಡ್ಬೇಕಾ? ಓಕೆ, ಇಟ್ ಇಸ್ ಆಯ್ತು. ಹ್ಮ್ 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 ಟ್ರ್ಯಾಕ್ ಫೋನ್ ಟ್ರ್ಯಾಕ್ ಮಾಡಿ ಅದನ್ನೇನ್ ಆಕ್ಷನ್ ತಗೊಳ್ಳಿ. ನಮ್ಗೆ
the other matters, then we'll go back to the attorney.
Passed over matters. Number 4, Suyagarla.
It's available. Mediation settlement is also. Yes. It is outside that it has been settled.
Nishana.
She has signed and gone. She was here. No, she was not. Hmm. You don't have any objection to that.
Very good. Missing.
Just a moment, just a moment. Hmm. Yes, in lieu of the permanent alimony, what is the arrangement? Yes, the. Handing over, fee over. DD. I heard key, so I was wondering what key it is. Yes. But the learned counsel appearing on either side. An application under order 23 of the CPC is also placed on record. Yes. It is submitted by the learned counsel appearing on either side that the disputes between the parties have been resolved and the terms of settlement are specifically stated in the application, full stop. It is submitted that the respondent is present in person and that the applicant is employed abroad and her mother, who's duly authorized to represent her as her general power of attorney on the basis of a GPA executed on 1st December 2022 is also available, full stop. It is submitted that pursuant to the settlement entered into between the parties, a demand draft for an amount of rupees 28 lakhs is being handed over in court today by the, drawn in favor of the appellant is being handed over in court today by the respondent to the GPA holder of the appellant, who is her mother. It is further submitted that the parties have, that the appellant has agreed to withdraw the criminal petition 711 of
तो क्या है? No, it's very impressive.
here and if they take up the examination, we will not go against
Stand
the
in the
orders
way.
of this honorable
Yes.
court.
My lord, I humbly
If
beg to
they are
submit.
following the rules and regulations, we have to obey the
No,
university rules also.
No, my
And
lord.
insofar as payment of fees is concerned, admitted fees is also not paid because of the pendency. of the
Payment of
proceedings.
fees, don't worry.
Yes.
That is the matter which we are
Yeah.
concerned with here.
Yes,
So at least the fees that was notified in the previous college, they definitely have to pay.
yes.
Then the question is whether they have to pay the fees that you notify or whether.
Addition.
That is the
is
question.
okay.
That is what is being decided.
Yes.
In the interregnum, on that ground, don't deny them
Yes.
attendance.
On that
or
ground, we will not deny. it.
we'll just clarify that.
Please.
If
May I?
anybody
Please.
is, as a matter of fact, doing that, please place it on record specifically so that
Please. My lord,
something can be done.
I feel, my lord,
We
if
will
my
not
lords,
strictly
if my lord says please to my lord, we will fairly, but we wish to fairly consider the honorable court as the admitted fees which we have actually paid to GR Medical earlier, my lords. We will continue to pay this time also, not paid. Now it's not paid.
Yeah. That is
First
the-
year that whatever we have paid,
In any case.
Please.
Where the second year fees is not paid,
please,
the second year fees that was being paid, that would have been liable to be paid in the
Please.
earlier institution.
please.
You will pay immediately.
That order, your lordship can mindly make sure that that meets the ends of justice, my lords. And 1 minute, and there's some time limit for the students to pay because now your lordship is making. And the second is, my lords, what my learned friend also points out probably is this, my lords. Now that the examination fees has to be paid, there's a time limit with the penalty is 26th of November. That, my lords, your lords may specifically direct them to receive the examination fees. And as far as the payment of the admitted fees,
For that, the post fee has to be paid.
that will pay. My lords, the 24th, one submission is, well, some of them now that all of us are undertaking to pay that amount, my lords. Your lordship may kindly, would we pray your lordships, my lords, now that we are already on 11th now, there's some time limit so that arrange for the funds that your lordship may fix, my lords. So we'll pay the admitted fees. So that ends the, please, please.
My lord, I'm appearing for respondent too, my lord.
Just a moment, please. Yes.
This aspect is there. First item in the box says last date for online entry of the general assessment marks for both regular and repeater students. Now that is 6/11.
That probably has not been done.
What it entails and means is this, that this is not going to be a smooth exercise for all of them. So what I would suggest to do is this. Let them, at this, let not direct that all the colleges shall submit the attendance records as well as the examination. Internal assessment and examination particulars within 7 days, let us say, as a first step. Then we will know what are the hurdles that come up. So please post this then on the 7th day and thereafter talk about the fees, etc. As I had mentioned last time.
Further time may be required.
The aspect is a 10-minute argument, nothing beyond that.
Yeah.
Same things will
Please.
as per NMC.
But
as far as. Because they have raised an issue, it is okay. Because
Nah.
the bus which was going to Dharwad, there was a breakdown. He said,
Yes.
here's the second bus,
Yes.
join this bus, same ticket applies. That's all the issue. If they are not ready for that bus, there are several other buses, including nationalized buses of the state, which will take over, the government will take over these students and putting the alternative. These colleges say no, NMC is okay with, they going to government colleges and continuing with their course. Government will be benefited with a higher fee, because government takes only about 1 lakh of rupees. Here they'll be taking 12 lakh of rupees.
Appears to be a very, very fair submission, my lords.
It would be possible for the government to say they will not.
No. Please,
Yes.
favor.
Yes.
Thing called the essentiality certificate, where they give an undertaking.
Yes.
That if there's a breakdown of a bus,
Correct.
we'll take it. So what happens by virtue of this is they're obliged to do so. What will happen is, these colleges, we have not increased their intake. We have just said you will go there standing in this bus. You won't get seats. It's a 36 capacity bus. You will have to go in the seat, in the standing capacity. There also they will have to go in the standing capacity because we are not increasing the intake. Because of this breakdown situation, we are going to recognize these students. We will not leave them in the lurch.
Correct.
Despite my lord's orders, my lord, they, please.
That these things have been complied with. 7 days later, we'll see what is the fallout of that. And then my lord may then. proceed.
But despite my lord's orders, attendance in many of the institutes, they have not entered the register, entered. Now, my lords,
one fear is, my lords, I am grateful for my learned friend, very fairly submitted how it's going on, my lords. One's fear is, my lords, now the institutes, they have not received the fees. They have not entered it for not having received the fees. Once the fees is received, they will enter it. Now they will come and say, my lords, there is no attendance. We'll be in a problem unless my lords permit us or direct us to pay the admitted fees within a prescribed time, my lords. This will be dependent on that.
What a more serious issue. If they do the internal assessment also, then we will know better. That's why I said, please direct that all the procedures should be complied with within 7 days. So we will know if they do the internal assessment part of it, then the sympanon would be that at least they were eligible. That's why they did that.
In the meanwhile, if anybody wants to pay the fees
Please,
and
please.
the colleges are accepting the fees, let that happen.
Please. And also admission, college examination fees also.
Let us, at this point of time, that would be my suggestion. Let us stick for 7 days at least to the admission process. I mean the examination process.
We are aware of the situation. Unless at least the admitted fee is paid, do you, as a matter of fact, think that they will not?
This will result in.
What will happen is they will come here and say,
There's
we
no
don't know,
attendance.
they have not paid anything. That is the problem.
That tussle will result in.
We've heard the learned counsel appearing on in these matters quite in detail. It is submitted by the learned counsel appearing for the petitioners, for the students, that in spite of an interim order granted by this court to the effect that that they will be permitted to attend the classes of the second year MBBS course and to appear in the ongoing as well as future internal and periodical examinations. Some of the colleges in which the students have taken admission have not, are not marking attendance of the students. And the examination fee with regard to the second MBBS examinations to be taken by them is also not being received from them. The learned counsel further submits that in all these cases, the students are ready and willing to pay the admitted fees which was notified in respect of the sixth respondent college, and that the colleges to which the students have been subsequently granted admission may be permitted to receive the said fee and to process their applications, process their attendance and internal assessment marks for enabling them to take the examinations of the second MBBS course. The learned counsel appearing for the university submits that a notification has already been issued with regard to the second MB examinations on 4/10/2024, where the last date for online entry of internal assessment marks and of internal assessment marks without fine has been notified as 6/11/2024, and that unless the attendance details and the details of internal assessment marks are made available before the university will not be able to permit the candidates to take the examination. Full stop. The learned counsel appearing for the NMC submits that in many of these cases, the fee might not have been paid, and unless it is known as to how many of the students are actually entitled to take the examination on the basis of the attendance and the internal assessment marks and the internal assessment which has been conducted by the respective institutions, further orders cannot be passed in this matter. Having considered the contentions advanced and in view of the earlier interim orders passed by this court, we are of the opinion that the students are to be permitted, students who have already been permitted to attend the classes of the second year MBBS course should further be permitted to take the examinations on paying the admitted fee.
Please.
In case they remit the admitted fee in the institutions to which they are readmitted, the institutions shall take appropriate steps to send the details of their attendance as well as the internal assessments conducted by them
Please.
to the university.
And
for-
also
As per
permitted to pay.
university rules.
as-
No, that again.
University for
They
not
don't
that way.
aggravate it.
for the purpose of permitting them to take the second MBBS
And also to pay the examination fees, my last and also to pay the examination fees. And
As
petitioners to permit it to.
That
Please.
that will come to.
Please,
Yes,
please,
Just
please,
after 7
Please,
days. Let us
please,
see
one
what happens.
aspect, my lords, in this, there are two IAs, my lords, by petition number 13, 14 and 15, seeking permission to be re-allotted to Dr. Ambedkar, my lords. That your lords may kindly, my lords, in the next case also,
That be permitted.
that's the same order as.
Orders
asked.
have been passed.
Please, my lord, we have produced it.
Yes. IA number, that is 5 and 6.
How?
The numbers.
Numbers,
you
I'm
had
sorry, my lord.
A confusion. I think it is 5 and 6.
Five, my lords, at least. 5 and 8, I feel, 5 and 8.
6 and 6 is something else. 6 and 7 is something else. 5 and 6. 5, only 5 in both.
In first matter.
In the first matter only.
IA number so and so. And where is the order
Order
passed?
code.
And where is the order passed in that IA you have produced?
Order is, I will pass on my, this is, it's passed in this case, my lord. That's on 2nd May 2024. This one could pass the order, my lord. 2nd May.
In this case.
Please, please, please. 2nd May 2024. May pass on.
Maybe in some other place. Nine three 9-4.
2nd May. It's
You have a
9394. Please, my lords. Online, Allah. I'm sorry, 2 copies. Copies are there in the record. I'm sorry, only 1 copy, sir. Please, man, 1 more copy. Court officer, please. ಕೊಟ್ಟೆದು.
IA number 5. Of
It is the relevant page is the page number. Which is
just a moment, just a moment.
IA number 3 is impleading in that case mirror. IA number 3
Is impleading.
Impleading a BR medical, Ambedkar Medical College.
Not going to happen.
They are ready to take, but
Please.
they require.
IA 3 is for impleading, my lords.
IA 3. You're sure it is for impleading?
Yes, please.
3. Yes, IA 3 of
24.
24. This is an IA filed seeking impleadment of the
Dr. BR.
proposed so-and-so respondent. 21.
21.
21st respondent as a party to this writ petition. Having considered the contentions advanced and in view of the averments in the affidavit filed in support of the application.
Go next to IA number. To direction.
And in the special circumstances of the case, including the fact that there is a communication annexure T.
T, annexure T, my lord.
And
Please.
the light of annexure T communication. The impleading application is allowed. The 21st respondent is brought on record
Please, my lords.
as a party to the writ petition. Issue notice to the 21st respondent
Please.
In the writ petition.
Please.
IA 5 after the.
By hand summons also.
Yes, by hand summons as well. IA 5 of 2024 in view of the averments made in view of the averments made in the affidavit filed in support of the application and in the special facts and circumstances of the case, and having heard the counsel appearing on all sides and perused the order dated 2/5/2024 in WP number 9394 of 2024 in identical circumstances, there will be a direction to the additionally impleaded 21st respondent who has expressed willingness by annexure T to accept. Who are the,
Petitioners 13, 14 and 15.
yes, petitions 13, 14 and 15. As to the second year course.
Please.
Second year MBBS course.
And permit
And to
petitioners to pay the fees, my lords.
To permit them to pay the admitted fees
And
and,
continue to
and to
continue the course there in that one.
continue the course in the said institution.
Please, my lord. I'm
Yes.
grateful, my lord. My lord, in the very next case,
Mm.
I'm coming now itself, very next case,
Mm.
there also, my lord, the admission to B.R. Ambedkar, my lords had permitted, but
Mm.
my lord directed that you go and pay the fees. That was the order, my lords.
Mm.
But now the Ambedkar says there should be specific order as my lord passed now.
This one,
Now student is attending in the next case, student is attending there
yes,
and,
and they are also on record in that case. As respondent.
on record, they're already on record.
Pleading is required now.
No, on record already.
Yes.
Already been impleaded.
No, which is the IA filed in that case?
In my lord, main interim prayer itself is for that purpose. To as per annexure D, permit them to continue.
Yes.
43.
Hmm.
43. No, I'm not for the university.
Therefore?
Speaking.
He appears for the university.
Ah,
As far as this petition, my lord, there is one petitioner.
Hmm.
And which offers two aspects. First one is whether they have submitted the application to the university, they have not submitted the application for the seeking for the transfer.
Hmm.
And insofar as this petition is concerned, the interim prayer is to transfer and admit the
Hmm.
student. Now, it's subject to the approval of NMC.
Hmm.
So university has no role to play in this.
Yeah, correct. University has no role because this honorable court has passed orders in all the cases, my lords.
can be-
Only
same
prayer is, my
orders can
lords.
be passed in this matter also. Hmm.
In the meanwhile, my only prayer is, please.
So you're suggesting that we can wait till the next date of
Yes.
posting for both the orders? For 42 also, it'll have to wait till.
My final transfer order, my friend is saying about final transfer order.
B.R. Ambedkar College issue notice to them. Let them also come on.
No, your lords may kindly see. In this case, B.R. Ambedkar is already on record.
Hmm.
They are not contesting because they have already given the letter at annexure D. We are attending the class. My only problem is, let me clarify,
Just
to
a moment, just.
payment of fees. No, not about that.
The second transfer.
Hmm.
After GR.
Then,
That has to be.
Hmm.
I'm suggesting because there are other students also. We do it as a block, so that it goes through as a common issue.
So there are only 3 students in that case. In the meanwhile, only because this, as this honorable court has done earlier, my lord, the transfer to Ambedkar, it was done by way of interim order. I understand, but the final orders may be passed, my lord, there afterwards, because now they have to attend a class, etc. Now they are attending the class in B.R. Ambedkar in the second case, my lords. Only thing is, as for the payment of the fees is concerned, my lord, they want a positive order.
it's an order, however it is directed that petitioner
Please.
shall, in the
Yes.
meantime, pay the fees at B.R. Ambedkar Medical College, respondent number 7 herein in the light of the letter dated.
My respectful submission is, my lord, the government, it appears, government did not give it in writing, therefore they stopped it and
This is not, or we cannot
as my lord, please.
pass orders upon orders.
Please.
Yes, in the first case, the same order now we have passed.
Please.
The second case, nothing.
That is
further
already
was
an
to
order.
that.
Only thing is the government had not given, my learned friend was not, learned friend for the government, my lords. In the second case, the petitioner says the government did not give the NOC. let him communicate, that's all, my lords. Because of that, let there not be
Please.
hurdles in the students, like only for that.
No, after that order, there is no affidavit on record either.
Please.
We cannot pass order.
As my
upon
lord, as-
Same order, we
please.
cannot keep passing again
Please.
and again. Yes. Yes.
There are nearly about 7 petitions of similar petitions.
Please.
Wherein except one, my lord, the transfer is sought for, my lord, for which they are.
We had said that all these matters should be listed. today
To be,
together.
but still. So let all these cases be,
So when the next date, when it is listed, we see that all those matters are also, or do you want this order? Listed tomorrow and day after. Yes, please give the numbers. Yes. Yes. Yes.
in my case, it may kindly be noted, my lords, because there is some hurdle.
I take on.
As my lord is.
Difficulty is this,
Yes,
there's nothing thereafter.
Yes.
So
Please.
to say that
No, let my learned friend communicate it.
do we as a court say that the a litigant has no objection to an order being passed or to complying with an order which is already being passed?
Practically what is happening is.
That you'll
That I
probably
don't
have to probably ask them to
Yes.
make some communication so that.
I'm very sure my learned friend will communicate, my lord, because he's very fair. The college has to communicate.
If that is not being done, some application has to be there before court. No, this, as a matter of fact, the difficulty is if the admission is not ratified, they probably will have problems with regard to writing the examination. So if any communication is required, please approach them, they'll issue
Please.
communication. Yes.
Please.
That it should not be restricted to only to the features in the petitions, there are 70 numbers there, which are where listed on file may not but order to be issued. My submission is that, regarding payment of fees, acceptance of
Please list it tomorrow and say that the order passed today will apply to those.
yes.
Only this, listed tomorrow. Yes, even if it is not scanned, listed tomorrow, so that we can say that this order passed today will apply
Yes.
to that also. Yes, listed tomorrow.
That
And
will
any
alleviate the
matters
problems of
which are
all the
there,
students.
Please give the number so
Please.
that they can be listed on 13th. So this order will apply to.
Please, all those.
Yes.
Oh,
Matters exactly 7 days, because otherwise you create a problem.
your lordship may kindly fix one specific date for the
20th.
next exercise, my lord. Earliest possible, because
19th. 21st. 20th.
20th. Please. Most good.
Yes. It is 2:30, so that after the. That's all. Have the parted matter and start with the parted. Followed in lecture.
230 matters, serial number 54. Rajeshwara PN.
Here, just a moment before you start, we are in the middle of a parted matter.
Well,
We thought we could go ahead with that and start it on a day when it is likely to be over. Please give, yes, please give the dates. Suggest a date, we can list it on that. 20. No,
This is a matter related to staff nurses seeking equal pay for equal work.
can we,
Another staff nurse is coming up on the same day, but it's a different issue.
20th? No. Let's have it on the week after that, because it appears that every day there are several matters listed. 2nd December, 23rd,
Lord,
This is
if I may
Saturday.
make one submission, I appear for the complainant in 54.3, my lord. Contempt, civil contempt matter. The issue, my lord, now I'm instructed that the complainants are not even being paid the stipends, my lord.
That was being paid, my lord, that would be paid to them. There's no
Please,
difference.
please see
Yes,
that,
I will-
at least
Even
that.
the stipends are not being paid, my lord, and the reason being assigned is that there is a writ appeal which is pending consideration.
Please see that
Nothing to do with
that
that.
is paid.
I will
Yes,
instruct them.
yes, learned.
Second, my lord. And 212. Much.
Great.
If it's 23rd, if everybody is ready on 23rd, it can probably, but it's a Saturday. We are alerting you.
Lord, it may be taken up on the 23rd, my lord, considering this
Yes.
urgency.
Yes.
Great.
Okay. 47, continuation.
Yes. Lord, before I go into the merits itself, just two aspects in respect of what the Supreme Court has said in the regard to the approach to be taken in regard to these kind of cases, my lord. First, what the Honorable Apex Court says is that in cases of in industrial adjudication, especially in respect of a sham contract, when that's the reference, what the role of the industrial adjudicator is to lift the veil, is to pierce the veil and look beyond the paper arrangement to see what is in fact, what is really happening. Look at the reality beyond the veil. So therefore, my lord, what the Apex Court says is that there may be papers, there may be paper arrangements, but what is required of the industrial adjudicator is to actually lift this, pierce it, get to the reality of the situation. So the very fact, the term sham or camouflage presupposes that there is something and which in fact is something else. So that is what that something else is to be looked into by the industrial adjudicator. The second approach that the Honorable Apex Court has said in industrial adjudication, my lord would be very well aware, is that it is to be done taking into consideration the constitutional ethos of social and economic justice, my lord. So therefore, it is towards the taking forward social justice and economic justice that industrial adjudication has to be looked at. In this vein, my lord, if I may just take my lords through the order itself, I'll not read what has already been read out. The reference, my lord, was in respect of that whether this contract is a sham. Additional issues were framed. Two additional issues were framed. Yes. One, my lord, was in respect of the locus of the union to raise this dispute. Yes. The second additional issue that was framed was whether there is a master and servant relationship. Yes. In respect of these two additional issues, there is an order that is passed on this. It is treated as preliminary issues and an order is passed on 4th April 2009, my lord. Subsequently, in respect of the issue of sham contract, the award is passed in 2012. There are certain findings of fact, my lord, which have categorically been found by the learned labor court. If I may just state what these are and take my lords through the papers. First, my lord, that the workers have worked from 1989. That is a finding of fact that the court has found, that they have worked from 1989. Second, that from 1989 to 96, there is no documents that are produced. Yes. There are no documents that are produced to show that there is a contract. Yes. Third, my lord, even the registration certificate, and I'll just show my lord that, is of the year 94. The registration certificate of the principal employer is of the year 1994. The fourth point, insofar as the finding of fact is concerned, it looks at the question of master-servant relationship and finds that the appointment, supervision, control, all of them are by the appellant. In respect of the question of sham, what the labor court finds is that there is no registration certificate, there is no license, there is no agreement.
Admittedly, the workers are working. Therefore, these workers are working under the appellant, and anything else that has been placed on record, which is for subsequent periods, are all only point to the sham and the camouflage nature of the contract. Having said this, my lord, if I may take my lords through the order of the learned Labour Court, dated 4/4/2009, which is on the preliminary issues.
Yes.
It is in volume number 4, my lords.
Page.
It starts from page 864.
Yes, we've seen that. Yes.
Please, my lord.
Annexure R.
Yes, please.
Yes.
My lord, some portions of it were read out. I'll not repeat those portions. If my lord could see, if my lords could see para 31, which is at page 891.
(891).
Yes, my lord. At page 891.
Yes.
Para 31.
Yes.
MW1.
Yes.
Please. MW1, in the course of his further cross-examination dated 24/8/2005, has admitted to the fact that on 1/4/1989, Nagnathpura plant was started. The first party workmen were the one who were appointed in the Nagnathpura plant since it started functioning. At the next breath, MW1 has volunteered that the first party workmen were appointed through a contractor. At this juncture, it may be observed here that MW1 has admitted the fact that these first party workmen were appointed in the year 1989. MW1 has not produced any contract labor agreement of the year 1989. It is also not the case of the second party that these workers were appointed through contractors in the year 1989 itself. The second party has not produced any kind of records or documents to establish the fact that the first party workmen were appointed through a contractor. When such is the circumstance, the evidence of MW1 to the fact that these first party workmen were appointed through a contractor in the year 1989 cannot be accepted. Thereafter, my lord, para 32, MW1 has further admitted to the fact that security department is the permanent department in the establishment. It is also admitted that security personnel are engaged round the clock. The security personnel attend to their work in shifts. It is explained that the shift schedule is prepared by the Assistant Security Officer, Security Agency, under the overall guidance of the security officer employed by the company. At this juncture, it may be relevant to mention that the second party has not placed any such records regarding the supervision by the security officer by the security agency in the year 1989 till the year 1994. For this reason, the evidence of MW1 in this regard is not convincing. Thereafter, my lord, some of these portions had been read out. In the para 33, 34 has been already read out, my lord, so I'll not go through that. If my lords could kindly see para 35 at page 896.
Yes, this is the primary order with regard to locus standi and the master servant. Other one is the final award.
Yes, may I, my lord? Para 35. This is in respect of WW1, my witness, WW1's evidence. WW1 Bandihal, in the course of his evidence, has deposed to the fact that his name finds place at serial number 2 in the order of reference. It's also his evidence that they are the real workmen of MICO, they are not contract workers. The plea of management of MICO that they are all contract workers is fictitious. There is a relationship of master and servant. Further, there is a dispute as the management of MICO refused to concede to settle the reasonable and legitimate demands. Nagnathpura plant of MICO was established for more than 13 to 14 years ago and it went into commercial production. In fact, my lord, WW1 in his evidence also says that when the plant started, we all started working. That is also something that is said. If my lord could, I'll not go through the entire bit of para 35. My lord could please see para 36. Para 36. It is his evidence. This is they're referring to WW1. That various mechanisms were adopted by the management to make it appear that they are not the workmen of the MICO, but they were working under independent contractor. It is only a paperwork done by the management. This is evidence that they have been able to get extracts of attendance registers maintained by the management for certain periods. All the entries in the attendance registers are made by the officers and supervisors of the management of MICO at Nagnathpura plant. The wages payable are calculated on the basis of the certificate issued by the officers of the MICO. MICO is Bosch, my lord, the appellant at Nagnathpura plant. The name of all the first party workmen are mentioned in the duty roster. The management was also maintaining MICO security personnel muster roll pertaining to Nagnathpura plant. These documents show that they are all the workmen directly employed by the management of MICO. The management is deprived the benefits to the first workmen by calling them as contract workers. They're doing the work on par with the permanent employees of Watch and Ward department at Aduvadi plant of MICO. They are all the so-called contractors are only name lenders. It is also his evidence that Terrier Security Services of Mr. Gardwell, Mrs. Unique has no license under the provisions of the Contract Labour Act. It is only subsequently that licenses are taken by them. It appears that the management of MICO has outsourced the work in the Watch and Ward department in Nagnathpura. Now, my lords, in this regard, the attendance registers at Exhibit W1 to Exhibit W7 are produced, which are for the years 1993 to 1995. At this juncture, it may be mentioned here that the second party has not disputed the original registers maintained by them, which are produced as Exhibit W1 to W7. Exhibit W1 is the attendance register for the months of May 93 to August 93. It is also not disputed that
Yes.
It is also not disputed that the name of the first party workmen are appearing in the register. The sanctioning authority has also signed in the attendance register. Exhibit W1 bears the name of the second party with its emblem. Exhibit W2 is the original attendance register for the month of November 1993 to December 1993, where also the names of the first party workmen are appearing. Exhibit W3, the original attendance register for the months of January 1994 to March 1994, wherein also the name of the first party work are appearing. It also indicates the signature of the persons who prepared it. Exhibit W4 is the attendance register for the months of August 1994 to November 1994. These contents indicate the name of the first party. Exhibit W5 is the attendance register for the month of February 95 and March 95. Thereafter, my lord, it goes into the other attendance registers for the other months. Para 37, my lord. WW1 has also deposed to the production certificate of Exhibit W8 to W50. On perusal of these certificates, it is evident that by virtue of fire services regarding the training undergone by the first party, wherein the address of the first party are mentioned as MICO, Nagnathpura, Bangalore. That is the appellant. Para 38, my lord, if I may skip the first few lines. Because it's about the conciliation report and all of that. 6 lines down, at this juncture, it may be observed that all the duty rosters indicate the name of the first party. Further, they are bearing the signature of MW1 PL Matthew. If the signatures on these duty rosters are compared with the signature of MW1 PL Matthew, they are one and similar. Then, my lord, it goes forward into also some other exhibits that have been marked by me, which include some cash vouchers. Para 39, my lord.
Yes.
Para 39. In the course of the cross-examination of WW1, it is elicited that Nagnathpura plant was established in the year 1989. It is denied that there were only contract security guards in their establishment right from the year 1989. My lords would recall, in his evidence, WW1 says, we are all working from 1989. What do they say? They say, you are working but as contract workers. So they don't deny the fact that we were working from 1989. At no point of time is that denied. Even in their evidence, is MW1 says, yes, they are working from 1989. So the fact that they're working from 1989 is clear, my lord. Apart from the fact that these attendance registers, which are from 93 and 94, clearly show all the first party workmen's name. Because an argument had been made that they were working for various...
Is that your claim petition says you work only from 1992 onwards?
Please, my lord. In fact, my claim petition says that it's from the time that the plant came into existence. That's what the claim statement says. They have looked at the reference. The reference, my lord, has no evidentiary value insofar as any other aspects that might have. The names of the workers can be viewed from the reference. Anything else that the reference says has no evidentiary value. And it has been clearly admitted that all of these workers have been working from way back from 1989. If I may just take my lords through certain, some other portions of this, of the order, my lord, which how the finding has been arrived at. Para 39, the next page, my lord, not the page on which it starts, the next page. On perusal of the, it's about 6-7 lines down. The line starts with year 1998. On perusal of the circumstances surrounding of this case, it appears that such an arrangement was made only to facilitate the first party workmen to continue their work subject to the disposal of their dispute raised by them. Even the version of MW1 in para 11 of his cross-examination makes it manifestly clear that they agreed so by keeping open all the issues. A submission was made that they gave letters up for appointment. That was something that an arrangement made by the court so that they don't lose their jobs during the pendency of this. And that has been accepted. So even the version of WW1 in para 11 of his cross-examination makes it manifestly clear that they agreed so by keeping open all the issues referred in the petition. Therefore, this was only a conditional order that was passed by this court for the purpose of convenience of both the parties. Then, my lords, if my lords could come to para 42. This is in respect of there was a submission made in respect of a civil court case that had been filed. That has been dealt with in para 42. In para number 33 of his cross-examination, it is elicited that they had filed a suit before Anekal Court through their union in OS 242 of 97 against Messrs. Terrier Security and Messrs. Gardwell Security. There might have been a request against Bosch, Myco, for not to extend agency to Gardwell Detective, but he does not know the details of the same. At this juncture, it may be relevant to mention about some of the records produced by the second party pertaining to the suit filed through the union before the Anekal Court. Admittedly, the management has produced a copy of affidavit of one GR Shivshankar said to have been filed before the Anekal Court, and it is at Exhibit M22. The management is placing reliance on para 3 of the said affidavit, wherein it is contended that the contract workers are working under the defendant number 2 and 3, corrections in some of the numericals in para 4 of the affidavit, and the year 92. At the outset, it has to be mentioned that Exhibit M22 is a Xerox copy of the affidavit. It is not a certified copy of the affidavit. The affidavit does not indicate the original number of the civil suit. The Xerox does not indicate the signature of the defendant and the signature of the advocate. It does not bear date also. Therefore, it would be difficult to place reliance on such a Xerox. For this reason, it has to be held that Exhibit M22 does not come to the help of the second party. Exhibit M23 is a Xerox copy of the order sheet in OS number 242 of 97 on the file of the Principal Civil Judge, Anekal, wherein Karnataka Rakshak and General Workers Union filed a suit against Terrier Securities, etc. It is the contention of the second party that the first party workmen themselves filed such a suit, admitting the fact of the service as a contract, and as such, the present grievance of the first party cannot be entertained. On perusal of Exhibit M23, it appears that an injunction suit was filed against defendant number 1, 2 from terminating the service. If my lord could come to the bottom of the page, the workers have no right to espouse the cause of the first party workmen. On the basis of the Exhibit M23 alone, the contentions that are raised in the present dispute cannot be brushed aside, since it relates to the year 1997. In the present dispute, we are concerned with the situation of the relationship existed from 1989 to 96. On this ground, it has to be observed that Exhibit M23 does not help the second party. Consequently, the order passed at Exhibit M23 does not bar the first party in raising the present dispute. In this, my lord, just insofar as this aspect is concerned, there's two submissions, my lord. One, that it is a settled principle that estoppel cannot act in industrial law to stop me from raising this dispute. In fact, there is a judgment of this honorable court, which has been upheld by the division bench, where in similar facts, where workers first said that we are contract, and then thereafter they raise another plea, they said that estoppel has no place in industrial law. And that has been upheld by the division bench. I'll come to that judgment. The second aspect, my lord, is that the role of the industrial adjudicator is to lift the veil and look at what is the reality of the situation. Even for an instance, suppose one were to say that I said my name is a contract worker, does not mean that that is to be accepted by the word. What is the real fact? What is the real relationship between the parties involved? That is what the labor code is expected to look into, to pierce the veil. So therefore, to say that I am stopped in any way, that has no place in law, my lord, apart from the fact that these documents cannot be relied upon. My lords could then see para 46 of the order. It's at page 909.
Yes.
Please, my lords. Therefore, the oral evidence of WW1, WW3, coupled with the admission of MW1 PL Matthew in the course of his cross-examinations, makes it manifest that the first party workman joined the second party for services in the year 1989. On the other hand, the second party has placed some of the records to contain the contractors as established. I have employed these first party workmen. As such, there is no such relation. Second party, as well as the first party, are placing relies on the citations. To be mentioned, the citations relied upon relate to the situation of the fact of the contract labor after coming into force of the Contract Labor Act. They essentially deal with the, my lord, I'll skip those portions. Yes. My lords could go 5, 6 lines down. It has to be borne in mind The relationship has to be decided with reference to the state of affairs that were prevailing at the time of production of materials by the second party. The registration certificate of the second party is of the year 1995. The fact that these workmen were working from 1989 to 1995 is also not in dispute. Therefore, there is no acceptable answer from the second party under whom the first party workmen were working as watch and ward from the year 1989 to 1994. In this regard, the workmen have placed attendance registered maintained by the second party, which are not disputed. Therefore, there is no impediment to place reliance on the attendance registers, duty rosters placed before this court by the first party worker. Then the question arises as to what was the occasion for the second party to maintain attendance registers of the first party workmen in the year 1993 itself. These registers reveal that they were not maintained by any labor contractor. The contractors now mentioned by the second party only relate to the year 1994 and onwards. The reliance is placed by the second party regarding the suit filed before the Unequal Court and the affidavit also are not helping the party to establish their contentions.
Yes.
Page para 47, my lords. It is no doubt proved that there is no appointment order by the second party, but it is not disputed that these workmen joined services in the year 1989 itself. The second party has also not produced any appointment order given by the contractor to the first party workmen as on the year 1989 to 1994. It is also not explained by the second party whether the license was renewed by them. So far as orders passed by this court regarding the arrangement in between the parties was only due to necessity and due to meeting of livelihood of these first party workmen, it is clear that such an arrangement was made without prejudice to the rights that are raised in the present dispute.
Yes.
Then, my lord, para 48 finally answers. Therefore, looking to the entire facts and circumstances of the present dispute, it cannot be said that there is no relationship of master and servant in between the first party and the second party. Documentary evidence placed by the first party reveals the relationship of master and servant. So therefore, my lord, the preliminary issue was answered, holding that there is master and servant. There's a clear finding of fact on all these aspects. This, the award, my lord, that was passed is at Annexure S. There are just few paras which were not read out, which I just want to point my lords to.
Yes.
It's the next page, my lords. Page 914, my lords.
914. Yes.
May I, my lord?
Yes.
Please. My lords, page 914, my lord. Annexure S. If my lords has it. My lords could see para 23. It's at page 926.
Yes.
Bottom of the page.
Yes.
Of page 926, my lords. My lords, this para was read out. I don't want to repeat it, but only to highlight the point that what they say 5 lines down from the para. They had agreement with Terrier Security Services, People's Choices, dated 25/7/1994.
Yes.
25/8/95, 96, 96, 96, and 97. Therefore, there's nothing that they have said in respect of the period from 1989 to 1994, admittedly.
Yes.
Then, if my lords could see para 24, my lords. Next page, page 927, my lords.
Yes.
Please, my lords. Page 9, para 24. This has also been read out. I don't want to read it out, only to point to the last part of this paragraph, my lords. At page 928. in respect of the payment of wages, the manner in which it was being made.
Yes.
The witness at page 15 says he was collecting the amount from the second party, including the salary of the workman and the other charges. In this case, it's evident the second party was paying the salary of the first party workman even through the MW2. He says, I collected it and I gave it to them. That's what he says. And therefore, effectively, the wages are paid through by the appellant. Then, my lord, the other para 25 is in respect of another contractor, which is much later. He joins only in 2005. Therefore, he's not, he's much later than the reference. If my lords could please see para 28 of the award. It's at page 930.
Yes.
When there is no legal and valid contract between the second party with the security contractor with respect to providing of the security personnel to the Nagnathpura plant, then the person employed for the security of Nagnathpura plant will become the employees under the second party. In other words, the second party becomes employer of these workmen who have in fact raised these disputes. Then, my lord, the Labour Code goes into the issue of license, which has also been read out. So I don't want to read that entire thing again. And insofar as the legal position is concerned, on that I'll just come to, my lord, to answer the contention of the learned counsel for in respect of the full bench judgment of the of this honorable court. My lords could just see para 38. It's at page 936, my lords.
Yes.
Exhibit page 936, my lords, bottom of the page, para
Yes.
38. Please,
Yes.
please, my lords. Exhibit M13 is the endorsement issued by the ALC Bangalore to the managing director of second party and also the president of the workers union. In it, it is intimated that there is an industrial dispute pending with respect to the regularization of the contract laborers. If my lords could turn over the page. In view, the 6 lines down, my lord. The line begins with given to the factory for watch and ward work. On the contrary, in view of the non-existence of any labor contract itself, in favor of any one of the labor contractors, the first party workmen, having continued to render their services as watch and ward of the second party, become the workmen under the second party, and the second party in turn will be the principal employer of the first party. And the order is passed, holding that they are the workmen of the second party, my lord, and also giving them various benefits of wages, etc., from the date of joining. So the
From 89 to 94, there is no contract.
yes, may I? Lord, one aspect, after the order was passed, after the preliminary order on preliminary issue was passed, they led certain evidence, other further evidence. That was challenged by me before this court. And this court, in fact, I have placed that judgment on with my memo of citation says that insofar as the issue of master and servant is concerned, the court has answered that question. That cannot be reopened in any form. The only question that has to be looked at is the question of sham contract, and that's the only aspect that remains. So insofar as a master and servant, any effort to reopen that with any additional evidence given subsequently cannot be looked into. That is something that this court has said, my lord, it's
Annexure R was challenged.
Annexure R was challenged, and thereafter they withdrew the challenge, saying that they will take it up both together. Annexure R was challenged. After Annexure R was challenged, after Annexure R, after that, certain other evidence was led by the appellant. That was challenged by me in the writ petition, saying that this issue of master and servant has already been looked at. So this court says, yes, this issue has already been done. That cannot be reopened in any way once that issue has been held. The only issue that is to be looked at is the issue of sham contract. And that's the only issue that you can limit to insofar as the subsequent, when the award is being passed. That is part of my compilation, my lord. I'll just take my lord's to that. But just to bring to my lord's attention that all of this evidence of the contract
Just asking you this, now that it is under challenge.
Yes.
The award annexure S can be challenged on the ground of the preliminary findings also.
Yes, my lord. My lord, insofar as a preliminary issue, because they said So what is under challenge is the preliminary issue
Yes.
and the award.
Hmm.
What cannot be done is to say that the award should have reopened the preliminary issue.
It
That
cannot.
cannot be argued. That's all my submission.
Okay.
My lords could take my compilation of judgments. Before I,
It is not a thing. It is not a thing. It is, the challenge is withdrawn saying at the time of challenge to the main award, they'll raise it. Yes.
my lords has my compilation.
Yes.
There are 2 volumes.
Yes. Yes.
If my lords could, sorry, if my lords could take the second volume. Two volumes of
Volume
my
2 is also in here.
Yes, please, my lords. Please.
Yeah, sorry, sir.
Please.
Yes.
It's at
Page
my
number?
page 379. Just to point my lords to the judgment, which I was referring to, so
Yes.
that I can close this issue.
Yes.
Page 379, it's in
Yes.
the last judgment.
Hmm.
This is workmen of Motor Industries Company Limited, that's me.
Hmm.
If my lords could see para para 388, I'm sorry, page 388. Para 7, heard the learned senior counsel for the parties, perused the pleadings and examined the order impugned, undoubtedly at the instance of the parties. The learned counsel having framed preliminary issues on the right of the union to espouse the cause of the workman, the existence of contract labor and the relationship of 72 workmen with the contract laborer, the existence of employer and employee relationship between the parties went to trial, examined their witnesses, followed by order dated 4/4/2009. Recorded a specific finding at para 47 that the arrangement between the parties was due to necessity make livelihood of the workmen, and such an arrangement with contractors could not be recognized under this act. In other words, this finding did partially cover the finding required to be recorded under the points of reference as to whether the contract cum arrangement between MICO and Messrs. Carrier Services and Systems and others was sham or not. It is also true that when the respondent MICO approached this court, petition was dismissed on the premise that the order could be questioned after an order is passed on the main reference if agreed. Thus, the efforts of the respondent to question the findings recorded by the Labour Court on issues which partially covered the point of reference to was thwarted. Thereafter, my lords, this court goes on to hold that insofar as only on the remaining issue that can be looked at, that issue that has been covered cannot be reopened.
Yes.
Now, my lords had asked a question in respect of what happens when there is no license. Learned Senior, when he was arguing, he pointed to the full bench decision of this court. It says that if there is no license, they cannot automatically become the employee of the principal employer.
Provided there is a contract in existence.
Precisely, my lord. Provided that there is a contractor, and those in that case, in fact, the principal employer has a registration certificate. That is in fact a specific noting that is made in that. My lords could just see that judgment for a moment.
Yes.
That sale was a sale contract workers union. Lords, I'm not sure if my paragraphs will match with my lord's para, so I apologize for the same.
That's all right. Yes.
I think my lords is just getting the judgment. Our Lord, this is sale versus sale contract workers union. It's the second judgment that they have relied upon. The second citation in their list. The question that has been referred right in the beginning, the first paragraph.
Yes.
Please, the first paragraph The question referred by the division bench for a consideration is whether the failure of the contractor through whom a contract labor is engaged to obtain a license under Section 12 of the Contract Labor Regulation and Abolition Act will bring about the relationship of employer and employee between the said contract labor and the principal employer. My lords would just see paragraph 22, my lords. I'm sorry, my lords, I have the LLN. The paragraph begins with, in the instant case, we have to examine the question under consideration, having the following circumstances. This is how the paragraph begins.
No paragraph.
There's no paragraphs at
Page number.
my lord, I think it may be, if I, I have, my lord, if the paragraph beginning with in the instant case, we have to examine the question under consideration, that's, it's somewhere in the middle, my lord. The paragraph before that is, there is no doubt that every workman employed, if my lord has that.
Yes.
It's the para after that, or maybe it is part of that. So it says, in the instant case, if my lords has it.
Yes.
Please, my lords.
Yes.
Please. It says, in the instant case, we have to examine the question under consideration having the following circumstances. There is no prohibition against employment of contract labor in the appellant's establishment. B, the appellant is registered under Section 7 of the Act. The contractor has not obtained any license under the Act. And thereafter, in the findings, which is the conclusion part, the last paragraph. For me, it's the last paragraph, point number 8, my lord. There is no warrant, absolutely no warrant to deem a direct relationship of employer and employee between the principal employer and the contract labor only because the contractor fails to obtain a license. So the limited question before this honorable court in this case was, if there is a contract, if there is a registration and there is no abolition and there is no license, then would they become, then can you say that they would become direct? So this case is clearly distinguishable. One, on that ground. Second, of course, my lord, here there is no contract agreement even. In this particular case, there is no agreement, there is no there is no registration certificate, there is no license. The second judgment that was relied upon, which is the Dinanath's judgment of the Honorable Apex Court, that, my lord, is in respect of the High Court exercising powers of abolition, abolishing contract under Section 10 because there was no license. So that's a completely different angle altogether. It is not to do with whether whether it's a sham or a camouflage. So the question of whether under Section 10 this can be looked at, whether abolition itself can be done under Section 10, was that really the question before the Honorable Apex Court? So that case also, my lord, does not really is clearly distinguishable.
Yes.
Is the paragraph what was read out only, my lord? So I don't want to repeat that paragraph.
Yes.
Because what was read out itself by Learned Senior Counsel was in respect of the abolition of the contract exercising powers under Section 10.
Yes.
So therefore, my lord, this judgment also would not really assist them in any way. On the contrary, if my lord could see my compilation, volume 1 of my compilation of judgments.
Yes.
Page 107, my lords. 107.
Yes.
This is 1999 SCC 601, Secretary HSEB versus Suresh and others. This, my lords, this was a case where they had taken a ground of, there were some Safai Karamcharis who were working there, and then they said that it was a sham contract. And all of these aspects are looked into. If my lords would see para 20, it's at page 119.
Yes.
Para 20, my lords, at page 119. If I may read. It has to be kept in view, this is not a case in which it is found that there was any genuine contract labor system prevailing with the board. If it was a genuine contract system, then obviously it has to be abolished as per Section 10 of the Contract Labor Regulation and Abolition Act after following the procedure laid down therein. However, in the facts of the present case, it was found by the Labour Court and as confirmed by the High Court that the so-called contractor Kashmir Singh was a mere lame lender and had procured labor for the board from the open market. He was almost a broker or an agent for the board for that purpose. The Labour Court also noted that the management witness so-and-so also could not tell whether Shri Kashmir Singh was a licensed contractor or not. The workman has made a statement that Shri Kashmir Singh was not a licensed contractor. Under these circumstances, it has to be held that factually there was no genuine contract system prevailing at the relevant time, wherein the board could have acted as only the principal employer and Kashmir Singh as a licensed contractor employing labor on his own account. It's also pertinent to note that nothing was brought on record to indicate that even the board at the relevant time was registered as the principal employer under the Contract Labor Regulation and Abolition Act. Once the board was not a principal employer and the so-called contractor Kashmir Singh was not a licensed contractor under the Act, the inevitable conclusion that had to be reached was to the effect that the so-called contract system was a mere camouflage, smoke screen, and disguised in almost a transparent veil, which could easily be pierced, and the real contractual relationship between the board on the one hand and the employees on the other could be clearly visualized. This is a case where they're looking at a question of a sham contract, where there is no registration certificate, there is no license. And they say that then the camouflage has to be pierced. And in this case, my lords, there is no agreement. The earliest agreement that they speak about is of the year 2005.
Yes.
I'm sorry, 95. It was of the year 95.
Yes.
So therefore, my lords, insofar as the question of what happens when there is no registration certificate, when there's no license, when there's no agreement, my respectful submission would be that the facts in the other two cases which are relied upon are clearly distinguishable. And in fact, it would be this that where there is similarity of facts which would come into play. Lords, before I go to my other judgments, which I will only go through very quickly, I just want to answer the question on locus. The argument that had been made is that the contract workers could not have, the so-called contract workers could not have actually raised this industrial dispute. What the labor court holds is that the union could not have raised this dispute, but there is a community of interest. And given that there is a community of interest, this dispute is maintainable. This is the finding of the labor court in the preliminary issue. My judgments, my lord, which I am relying upon at the first judgment in my compilation.
Yes.
Workman of Dharampal Premchand, page number 5.
Yes.
Page number 5, it's a continuation of paragraph 9. The majority union, of course, can raise a dispute, and if a reference is made under section 10(1) of the Act at its instance, the reference is valid. Similarly, if there is no union of workmen in any establishment, a group of employees can raise the dispute, and the dispute then becomes an industrial dispute, though it may relate to the dismissal of an individual employee. In this particular case, it was in respect of a dismissal of an employee. How does an individual dispute become an industrial dispute? The point is that there is a community of interest.
Pre-amendment.
Please, ma'am. Then this certainly can be raised. Then, my lord, the next judgment, Tata Chemicals versus the workmen at page 8. At paragraph 16, my lords. Paragraph 16 is at page 18. In fact, this is also a judgment that the Labor Code looks at.
Yes.
Page 18, my lords, if my lords has it. It's a continuation of paragraph 16. The conclusion that a minority union can validly raise an industrial dispute gains support from section 2K of the Act, which does not restrict the ambit of the definition of industrial dispute to a dispute between an employer and a recognized majority union, but takes within its wide sweep any dispute or difference between employer and workman, including a minority union of workmen, which is connected with the employment or terms of employment or conditions of labor of workmen, as well as the observation made by this court in Workmen versus Dharampal Premchand. So therefore, my lords, it's not necessary that you have one recognized union, only they can raise a dispute. And finally, my lords, if my lords could see page 22, Gujarat Electricity Board, which in fact actually specifically says that I can raise this dispute. Page 22, Gujarat Electricity Board versus Hind Mazdoor Sabha. At page 46, Mal.
Yes.
I'm sorry, my lord, para 46, page 53, ink page 53. May I, my lord? The last but equally important question that remains to be answered. Who can raise an industrial dispute for absorption of the workman of the ex-contractor by the principal employer? As has been pointed out earlier, if the contract is not genuine, the workmen of the contractor themselves can raise such dispute. Since in raising such dispute, the workmen concerned would be proceeding on the basis that they are in fact the workmen of the principal employer and not of the contractor. Hence, the dispute would squarely fall within the definition of industrial dispute under Section 2K of the IDEA Act, being a dispute between the employer and the employees. In that case, the dispute would not be for abolition of the contract labor, but for securing the appropriate service conditions from the principal employer on the footing that the workmen concerned were always the employees of the principal employer and that they were denied their dues. In such a dispute, the workmen are required to establish that the so-called labor contract was a sham and was a camouflage to deny them their legitimate rights. So therefore, it is clear. Suppose I'm saying abolish, then it's a different question altogether. Suppose there is a finding that the contract is genuine, then the contract workers themselves cannot come forward. But here, when the workers say that I'm not a contract worker, I am in fact a direct employee of the principal employer, and this entire contract is nothing but a sham and a camouflage, then I can raise this dispute myself. I'm not dependent on any other permanent workers union or any other union to raise this dispute, notwithstanding the fact that I have community of interest involved. So therefore, my lord, insofar as the first issue is concerned, the issue was in respect of locus. Locus, it's very clear that there is community of interest, and in light of the judgment of the Apex Court in Gujarat Electricity Board, when I'm saying that there is a sham, when I'm saying that there's a camouflage, when I'm saying this contract does not exist, then certainly the workmen, they can raise the dispute by themselves. They don't need any other workers. In any event, even a minority union can raise a dispute. And so therefore, I'm not barred in any way by raising this dispute. A question was raised insofar as a registration of the union was concerned. In fact, my lord, it is registered. There is a specific plea to that effect. In the evidence, it has come out that it is registered. They don't deny that fact, just to bring, since that point was raised. Yes. So that the registration is, there's no question. Insofar as the second issue is concerned, my lord, in respect of the master and servant relationship and the question of a sham contract. Yes. In respect of the master and servant relationship and the sham contract, what the evidence that has been recorded and the findings of fact that have been clearly recorded by the labor court would show that one, workmen are working from 1989. There is nothing from 1989 to 1995 to show that there's no contract. I'm sorry, my lord, I recognize that I'm repeating myself. There is no contract, there is no registration certificate, and there is no license. 95, and any documents that they produce subsequent thereto cannot be relied upon because it is subsequent to the reference. And even those documents, because there's no registration certificate and there's no license and there is no agreement, those cannot be considered as a legal and a valid contract. So therefore, when there is no registration certificate, even let us say for a moment there's no license, then this entire arrangement is nothing but a sham. The judgments that I have relied upon, I'm sorry, before that, my lord, the labor court has also looked at the issue of control. It has looked at the issue of control. It has looked at the issue of supervision by looking at attendance registers, by looking at the duty rosters, and by looking at the certificates that were issued for their training in firearms, in fire emergencies. So all of these aspects. So there is no contract and there is a clear control, supervision, and appointment by the appellant. And it's taking into consideration all of these aspects that the labor court has arrived at the finding that there is a master-servant relationship and that there is a sham. The judgments that I have relied upon, my lords, if my lord would just see the compilation, I'll just very quickly just point to some of those judgments. I have already taken my lords to Secretary HSCB versus Suresh, which is the 8th judgment. The first 3 judgments are in respect of the locus standi and community of interest. Yes. The 4th judgment, which is Workmen of Food Corporation versus Management of Food Corporation of India. That is the case where initially the workers were working directly with Food Corporation of India. Thereafter, they bring in a contractor. What the Supreme Court says is that once they were directly working, without actually retrenching them or stopping them, you cannot bring in some third person and thereby deny their original rights, which is somewhat similar to what is attempted here, notwithstanding the fact that this is also a sham. My lords would, and the 5th judgment, my lord, is Hussain Bhai versus Alat Factory. In that, my lords, page 83, if I may just take my lords to the test that has been laid down. Page 83, my lords.
Yes.
Para 5 at page 84. This is the test of who is a workman and an employer. For a very celebrated case, the true test may with brevity be indicated once again, where a worker or group of workers labors to produce goods or services, and these goods or services are for the business of another. That other is in fact the employer. Here, of course, that is the appellant. He has economic control over the worker's subsistence, skill, and continued employment. If he for any reasons chokes off, the worker is virtually laid off. The presence of intermediate contractors with whom alone the workers have immediate or direct relationship is of no consequence. When on lifting the veil or looking at the conspicuous of factors governing employment, we discern the naked truth, though draped in different perfect paper arrangements, that the real employer is the management, not the immediate contractor. So the test is, what is the work that is being done by the worker? And who does it go to support?
Yes.
In fact, they warn us back then itself, my lord, myriad devices, half hidden in fold after fold of legal form, depending on the degree of concealment needed, the type of industry, the local conditions and the like, may be resorted to when labor legislations cast welfare obligations on the real employer, based on Article 38, 39, 42, 43, and 43A of the Constitution. The court must be astute to avoid the mischief and achieve the purpose of the law and not be misled by the maya of legal appearance.
Yes.
Then, my lord, the judgment on Darangadara, I'll not go through, my lord. I've extracted the portions in my synopsis. If my lords could just see the Secretariat versus Suresh, my lord, I've already taken my lords to at page 121.
Yes.
Only because the facts are similar, my lord.
Yes.
Indian Petrochemicals Corporation Limited versus Shramik Sena. Page 121 is the judgment. Page 128. The page number that is ink page 128.
Yes.
The first column on the left, bottom of the page, before the numbering starts. A perusal of the affidavits filed in this court and the contract entered into between the management and the contractor clearly established. Canteen has been there since the inception of the appellant's factory. Long years, and despite change of contractors, the workers have continued to be employed in the canteen. The premises, furniture, fixture, fuel have been provided for by the appellant. Wages are to be reimbursed by the appellant. The supervision and control on the canteen is exercised by the appellant through its authorized officers, as can be seen from the various clauses. Contract is nothing but an agent. Considering para 26, considering these facts cumulatively, in addition to the fact that the canteen in the establishment is statutory canteen, we are of the opinion that in instant cases, respondent workmen are in fact the workmen of the respondent management. Here too, in fact, they say in their evidence, which is also noted, that the cabins are provided by the appellant. The place to stand is provided by the appellant. Learned senior had read out, I use the canteen of the appellant.
Yes.
The next judgment, my lord, is Indian Overseas Bank. That also, my lord, looks at the issue of lifting the veil. It's at paragraph 20. Sorry, my lord, may just see page 140. Paragraph 20 is at the bottom of the page.
Yes.
The standards and nature of tests to be applied for finding out the existence of master and servant relationship cannot be confined to or concretized into fixed formulas for universal applications invariably in all class or category of cases. Though some common standards can be devised, the mere availability of anyone or more in the absence in a given case cannot be by itself to be decisive of the whole issue. That being the position, in order to safeguard the welfare of the workman, the veil may have to be pierced to get all the realities. Therefore, it would be not only impossible, but also not desirable to lay down abstract principles or rules to serve as ready reckoner for all situations, thereby attempts to compartmentalize and peg them into pigeonholes formulas. This would only help to perpetuate practicing unfair labor practices than rendering substantial justice to the class of persons who are invariably exploited on account of their inability to dictate terms relating to conditions of service. So the role is to lift the veil, my lords. My lord, the last judgment I'll rely upon insofar as this issue is concerned is at page 148. the judgment of this division bench of this honorable court at page 148, the management of National Aerospace Laboratories versus Engineering and General Workers Union.
Yes.
This, my lord, in fact, was challenged before the Supreme Court. Supreme Court had upheld this, judgment. Para 25, my lords. In this as well, the issue was of a sham contract, where it was held that the contract itself is in fact a sham. Page 183. My lords.
Yes.
Please. Para 25. It emerges from the guarantees and ideals enshrined in the Constitution in the form of directive principles of state policy and the goal of social and economic justice laid down in its principle, that they ought to be the guiding principles for justice delivery by the courts and tribunals. The underlying aim and object of adjudication of an industrial dispute is, in effect, dispensation of social and economic justice and translating fundamental rights as well as directive principles into some tangible relief. As held in State of Bombay versus Hospital Mazdoor Sabha, regarding understanding the scope of industry, trade and business, industrial adjudication has necessarily to be aware of the current of socio-economic thought around. It must recognize that in the modern welfare state, healthy industrial relations are a matter of paramount importance and is essential function to assist the state by helping the solution. My lord, I'll just skip that portion. My lords could just see page 184. Thus, the process of industrial adjudication is an onerous task being guided by the constitutional mandates and aimed at settlement of the industrial dispute on a fair and just basis, tested on the touchstone of social and economic justice. When an industrial dispute is raised, it is a commotion to be pacified by dispensing justice. In such adjudication, not just the right to equality and other constitutional guarantees, but the aims and ideals of the Constitution enter into the consideration. An analysis of the constitutional scheme shows that by its very preamble, the Constitution is dedicated to securing to all its citizens social and economic justice. By virtue of Article 37, the principles contained in Part 4 are fundamental in the governance of the country. Dr. B.R. Ambedkar said before the Constituent Assembly in this context, my judgment, the directive principles have a great value for they lay down that our ideal is an economic democracy. Because we did not want merely a parliamentary form of government to be instituted through the various mechanisms provided in the Constitution without any direction to what our economic ideal or as to what social ideal ought to be, we deliberately included the directive principle in our Constitution. It is a duty of the courts to apply directive principles in interpreting the Constitution and law. Then, my lords, in para 27, this honorable court has looked at Article 38 of the Constitution, Article 39, 40, 41, and 42, 43. And then, my lord, at para 28. These aims and ideals, coupled with the duty to follow them, are cast in the Constitution to keep them constant and above the vicissitudes of political ideology and economic policy. When an industrial adjudicator having the power to transcend contractual conditions of service entertains an industrial dispute, he exercises the judicial power of the state and endeavors to secure for the industrial worker work, a living wage and conditions of work, ensuring a decent standard of life and full enjoyment of leisure within the limitations laid down by law and binding precedents. The jurisdiction of an industrial tribunal, therefore, is expansive and creative and not restricted to only enforcing or interpreting the contract of service or the extant legal provisions, and it's not fettered by the limitations of contract and can even involve extension of existing agreements or the making of a new one, or in general creation of new obligations or modification of old one. If the employment of a portion of the workforce on casual, temporary, irregular basis in violation of the express provision of the ID Act, or if it amounts to an unfair labor practice on the part of the employer, such illegality or unfair labor practice must come to an end with the adjudication. Particularly if the practice of employing workmen on a casual or temporary basis through a sham arrangement were permitted, it would amount to license to exploit and would fly in the face of every constitutional aim, ideal, edict, and obligation referred herein above. In the above facts, after confirming the factual finding that the arrangement of contract labor by the petitioner was a sham, the next logical conclusion would be that the workmen concerned were in fact employed for nearly a decade or by now longer for and by the petitioner. And the object of not making regular appointment in a legal manner was to continue such workmen without conferring upon them any status and privilege of regular workmen and without undertaking the process of regular recruitment. That would obviously amount to an unfair labor practice, which may not be strictly be punishable, but would be well not to be countenanced in adjudication of an industrial dispute.
Yes.
Please, my lord. So in fact, my lords, one of the unfair labor practice, Schedule 5, one of the specific entries in the fifth schedule, my lord.
Idea.
Yes. Unfair labor practice on the part of the employer. Serial number 10. Fifth schedule.
Yes.
To employ workmen as badlis, casuals, or temporaries, and to continue them as for years with the object of depriving them of the status and privilege of permanent workmen. In fact, one of the judgments that I have placed along with my compilation in the second volume specifically looks at this. It's Sudarshan Rajput versus UP State Road Transport Corporation. It's the second volume. It's at page 220. Both Sudarshan Rajput as well as ONGC Limited versus Petrol Coal Labor Union at page 240. They both look at this issue of unfair labor practice. And my lord would see page 234. At page 234, para 26. This is Sudarshan Rajput versus UP State Road Transport Corporation.
Yes.
Para 26.
Yes.
5 lines down, my lord. Further, we hold that even if the plea of the employer is accepted, extracting work through a permanent nature continuously for more than 3 years, the alleged employment on contract basis is wholly impermissible. Therefore, we have held that it amounts to an unfair labor practice as defined under Section 2RA of the ID Act 1947, read with Section 25T, which is prohibited under Section 25U, Chapter 5C of the ID Act 1947. Similarly, my lords, in ONGC, at page 261.
Yes.
Page 261 is the second column, my lord. It's a continuation of para 41, second column, right below the citation 2011. Said contention of the learned senior counsel is wholly untenable in law. And the reliance placed on the aforesaid case is misplaced for the reason it's an undisputed fact that the workmen have been appointed on term basis via memorandum of appointment. Thereafter, they were denied their legitimate rights to be regularized in the permanent post. Said fact was duly noted by the High Court as per the contention urged on behalf of the corporation and held on the basis of facts and evidence on record that the same attracts entry item number 10 of Schedule 5 of the Act in employing the concerned workmen as temporary employees against permanent posts who have been doing perennial nature of work. Here too, my lord, perennial nature which has been admitted and continuing them as such for a number of years. We affirm the same as it is a clear case of an unfair labor practice on the part of the corporation as defined under Section 2RA of the Act, which is statutorily prohibited under Section 25T of the Act. And the said action of the corporation warrants penalty to be imposed upon it under Section 25U of that. In fact, the said finding of fact has been recorded. In fact, what they also say is that even if I don't plead that it is an unfair labor practice, even then, that does not stop the courts from holding that it's an unfair labor practice when it is seized of the facts.
Yes.
The other judgments, my lord, that State of Bombay versus Hospital Mazdoor Sabha, it has been referred in the other judgment. I'll not go on that. J.K. Cotton Spin and Winnie, that is also in respect of the angle of social justice to be considered. And of course, Harjinder Singh, my lord, deals elaborately with that. The other two judgments are in respect of the powers, my lord, of this honorable court, which I'll not trouble my lords through because my lords is well aware of that. Sangram Singh and Syed Yaqub in respect to the only judgment that I want to take my lords through is a estoppel, my lords, in respect of the argument that was made that I have filed a suit somewhere and therefore I cannot come here. At page 347. At page 347, there's a judgment of the learned single judge, which is upheld by the division bench, which I also have placed on record. Paragraph 10 at page 349.
Yes.
Paragraph 10. Secondly, it is contended that the workmen on an earlier occasion pleaded that they are contract laborers, and therefore they are now stopped from contending that they are direct employees under the management. In support of the contention, If my lords has it, it's
Yes.
at page 349,
Yes.
paragraph 10.
Hmm.
Please. And they are now stopped from contending that they are direct employees under the management. In support of this contention, learned counsel for the petitioner relied on annexure, B copy of the order dated so and so, a report submitted by the subcommittee on the possibility of abolition of contract system in Mysore paper mills and so and so in Bhadravati. I decline to accept this contention of the learned counsel for the petitioner. Firstly, the doctrine of is not applicable to labor jurisprudence.
Yes.
And this judgment, my lord, has been upheld by the division bench of this honorable court at page 352. Of course, my lord, the issue of estoppel also, there is no estoppel against statute or public policy. And to permit them to be employed in this manner in an arrangement which is clearly sham is nothing but against public policy. That is the last judgment that I have produced, which is income tax, which is Commissioner of Income Tax versus B.N. Bhattacharya. It's a general principle of estoppel since it was argued at page 58, at paragraph number 58, my lords, page number 375. My lords, has at para 58. The soul of estoppel is equity, not facility for iniquity. Nor is estoppel against statute permissible because public policy animating a statutory provision may then become the casualty. Estoppel can only be in furtherance of any form of equity, not to deny workers their legitimate rights. So therefore, the argument that was made, my lords, is in respect of relying upon that, apart from the fact that in any way it does not bar me from from raising this dispute. It cannot, that argument cannot stand in light of the fact that estoppel does not apply in these cases.
Yes.
So therefore, my lords, in light of this, it's my respectful submission that there is I have not taken my lords to the judgment of the learned single judge, which also goes through all of this in detail, upholds these findings, takes note of the fact that there is absolutely nothing perverse, nothing wrong with those findings, and upholds it. It's my respectful submission that there is no interference required in either the labor court's order on preliminary issue or on the award. And the honorable, the learned single judge has also looked at it in detail. And therefore, it's my submission that it may be dismissed.
My lord, can I reply tomorrow, my lord?
Do you require a long reply? Now the question is boiled down to this.
I will
Whatever is
answer
the-
all those mislead. I'm very, very sorry to say this. I
No,
will
just
come
a
and
moment,
explain to
counsel.
your lordship.
Just a moment. The only question is, what was we don't need to look into the evidence in extenso. The question would be this: what was the material produced by you to show that there were contracts between 89 and 90?
89 is
94?
irrelevant. I will show to your lordship.
That is the only
They are
question
our
that-
admission. There is no plea to that effect that we were in employment from 89. Let them show one plea, my lord.
We'll see.
I will
Yes.
concede the case.
Yes.
There is no plea that they are in from 89. I will come and argue tomorrow, my lord, if your lordship permits. That is a bogus plea that was raised.
But there's only one aspect, not on the merits itself, because Leonard Senior continually said that they continue in employment. What actually happened was these workers who were there in 2020, my lords, they were transferred. That transfer order was stayed and subsequently has been declared as illegal by the civil court. Upon which we had in fact filed an application before this court seeking for payment of wages. This court has passed 2 orders in 2022 and 2021 directing them to make this payment of wages, which they never made, my lord. So till today, in fact, these workers who are there, from 2020 onwards, till today, they have not been paid their wages, despite an order of this court, having directed them to make this. Of course, this is not on merits, my lord, but to bring to the attention
I will answer
the
that, my
various
lord.
ways in which they have
Please.
tried to.
No,
They have tried to make it so difficult for the workers to even fight this case.
Very good. I will answer that. Why they are not earned the salary?
Yes.
Tomorrow, my lord. Amendment.
Can we list it tomorrow, see whether it is possible before lunch? If it is possible, then we can take it. We can list this tomorrow. If it's possible for it to be taken up before lunch, we'll finish it off.
I will finish within half an hour.
Okay,
Half an hour.
tomorrow.
That's all.
Must wait.
Yes,
Half an hour commitment.
Much obliged.
yes.
Number 14.
But it so happens that
Yes.
similar, there are a number of colleges of Ayurveda which have approached this honorable court, my lord, and various other high courts. In similar situations where due to some reason, they were not able to actually go through counseling, but candidates were qualified. Candidates were NEET qualified. That is the central exam. In such circumstances, this honorable court has passed interim orders continuing the student career of these
Yes.
just these orders. AST. One such order, not is Justice Kamal's order in Dharwad bench about 3 months ago. Kindly see para 2, Lord, the matrix of facts. By order dated
Yes.
3/3/23, this court had permitted the petitioner college to admit 60 students for the academic year 22-23. The issue then at hand was the alleged lack of infrastructure at the petitioner college. Petitioner college then had undertaken to provide all facilities, allow inspection, and if any lacuna was found, to rectify the same within the time. In under such circumstances, the court had permitted the petitioner college to admit 60 students for academic year. So as para number 3 of the said order, this court has also specifically right to respond number 4, examination authority, to include the name of the petitioner for the purpose of counseling. A year later, facts, the situation of the case seems to have taken a different turn. In that, G.S. Kannur, learned senior counsel appearing for the counsel for the petitioner college, that though all directions issued by this court in the interim order 3/3/23 have been complied with in letter and spirit, the students who are admitted pursuant to the said order are unable to take up the ensuing examination. He further submits that though this court had permitted the petitioner college to admit 80 students, only 22 students were available for the course, and according to the petitioner college had taken them for the academic year 22-23. Since the permission was granted by this court on 3/3/23, by which time the process of counseling by respondent number 4 had been completed, and the said 22 students could not be taken through the counseling process and were given admission directly by the petitioner college. This is the matrix of facts.
This is the problem.
Issue. This lack of compliance of taking these 22 students through the counseling process as mandated by the National Commission for Indian System of Medicine, by its notification dated 16/2/22, has come in the way of they taking up ensuing examination, as the respondent authorities are declining to permit them to take up the examination. It is this issue which has prompted the petitioner college to move this matter for consideration of the interim prayer. Learned senior counsel submits that though the petitioner was permitted to take 60 students, only 22 students sought admission and there were no other takers to the remaining seats. He further submits that lack of compliance with the counseling process in the circumstances shall not be held against these 22 students, as there are excess seats available and no prejudice would be caused into anyone whomsoever. He submits that in view of these peculiar fact situation,
The request and prayer of the petitioner college and students be considered in interest of justice. The learned counsel appearing for the respondent number 4, drawing attention to this court to regulation 57 so and so, dated 16/2/22, issued by the National Commission for Indian System of Medicine, submitted that said regulation requires strict compliance and they prohibit admission to students otherwise than through the process of counseling, barring foreign students. Thus, the issue submits that regulations cannot be relaxed. Then Lord Kanavi's arguments are taken note of. Court considers this 8, para 8. This court is conscious of the fact, shall I read, no? That the regulations brought to its notice by the learned counsel for the respondent number 4 may have to be applied in their letter and spirit. But the object, scope, and purpose behind the said regulation cannot be lost sight of. The said regulation which become handy if there is a demand more than the available seats. In other words, as in the case of the petitioner, college at hand when permitted the strength of students for the batch is 60 and only 22 students are being taken. Insistence of strict application of process of counseling may cause more harm than benefit. Further, it is not that the said 22 students could not go through the counseling process in the normal circumstances. As already noted, this court by order 3323 was permitting the petitioner college to admit 60 students for the academic year 2023 and specifically right to respond number 4 examination authority to reflect the name of the petitioner college for the purpose of counseling. It was, however, brought to the notice of this court, the counseling process had already been completed by the time the said interim order was passed. No default can therefore be said laid at anyone's threshold. However, these 22 students who have been admitted are now facing the difficulty of taking up ensuing examination merely for the formality of not complying with requirement of regulations 5, 7, 9, and 10. In the overall circumstance of the matter being present to the fact situation, this court deem it appropriate to allow the application. Response 2 and 3 are directed to issue necessary approval to respond number 5, who in turn shall permit the 22 students who have been admitted to the academic year 22-23 to BAMS in terms of interim order 3323 of this court to take up the effective online course and examination as per notification dated 23/5/24, produced at document number 1 and announce the result. It is further made clear that this interim agreement is made keeping in view the facts narrated above subject to the outcome of the writ petition. That's how the learned single judge dealt with the matter. Then the Madras High Court had an occasion to consider similar situation in the year 2022. Is on judgment. Exactly. A number of writ petitions came forth. Usually this issue arises with respect to Ayurvedic colleges because other colleges there is more demand than the number of seats available for normal streams of medicine. But in this stream, the demand is
As
less.
a matter of fact, you have all your recognitions in place.
Yes, yes.
By the time the seat matrix and the
Yes.
counseling starts.
Yes.
This would not arise.
Yes.
This normally arises when there is some kind of dispute with regard to the facilities available in your college.
Yes.
Whether you're entitled to offer these seats for the
Yes.
current year or not.
Yes, of
And
course,
then-
we had recognition. That is the situation.
Hmm.
We had the recognition,
Hmm.
but what happens is usually this is the reality. What
Hmm.
happens is many students would have tried the medical streams. On not being able to get those streams, there is a fallback. And when there is a fallback, they seek applications here. And what has happened in our case?
That is, if as a matter of fact, everything is in place as on the date when the counseling starts, then this will not arise. It
Yes.
cannot arise.
Yes.
It arises because there is some conflict
Yes.
with regard to your eligibility for admission for the year
No,
in
ma'am.
question.
So far as that is concerned,
Hmm.
the eligibility criteria is the NEET.
No,
Yes,
we don't, your eligibility to admit students.
that is there. That is there. Ma'am.
That is the difficulty.
Yes,
It-
yes, yes.
So it's only when some such dispute arises that this problem arises.
This problem
Otherwise,
arises.
your seats are there,
Yes.
you're expected to take the students through counseling.
Counseling.
And if your seats are filled, they're not filled.
Yes.
There's nothing further
Yes, yes,
uh,
yes, yes.
about that.
In our case,
Here,
Lord, it has
it's
so
when-
happened.
When there is some interim direction with regard to, I mean, you have to approach the courts
Yes.
saying that we are entitled to admit the students by the time the counseling is over.
By the,
That
that's
is how
the,
this happens.
precisely not the
Yes.
situation. And Lord, here it is what has happened. We have a 60 intake, this college, this petitioner college. We have been only able to admit 42 students and 40 students, but balance 20 are still vacant. So these situations arise in these streams where it is not a sought after course. In this Madras High Court judgment,
Yes.
and all of them have passed through NEET. In this Madras High Court judgment, page 12. Yeah, from para 8, not page 15.
Yes.
In similar fact situation, Lord. The Honorable Supreme Court clarified that restriction laid down in Dar es Salaam Education Trust case would only apply for admission to UG courses and would not apply even to PG courses. Hence, we are concerned with admissions of courses imparting Indian medicine and homeopathy. Therefore, on this ground, I hold the decision made in Venkateshwara case will not have any application. On the other hand, in my view, the issue raised in these petitions is no longer a integra. The Honorable Supreme Court in decision reported in 2021 as held as follows: the right to admit students, which is a part of the management's right to occupation under Article 19(1)(j) of the Constitution of India, stands defeated by Rule 12(8)(a) as it prevents them from filling up all the seats in the medical courses. Upgradation and selection of subject of study is pertinent only to postgraduate medical course. Insofar as undergraduate medical course is concerned, the upgradation is restricted only to a better college. Not filling up all the medical seats is not a solution to the problem. Moreover, seats being kept vacant results in huge financial loss to the management of the educational institutions, apart from being a national waste of resources. Interest of general public will not be subserved by seats being kept vacant. On the other hand, seats in recognized medical colleges not being filled up is detrimental to public interest. We are constrained to observe that the policy of not permitting the managements from filling up all the seats does not have any nexus with the object sought to be achieved by Rule 12(8)(a). The classification of seats remaining vacant due to non-joining may be based on intelligible differentia, but it does not have rational connection with the object sought to be achieved by Rule 12(8)(a). Applying the test of proportionality, we are of the opinion that the restriction imposed by the rule is unreasonable. Therefore, Rule 12(8) is violated for so and so. Respectfully applying the aforesaid ratio, I hold that writ petitioners' college managements are well within their rights to fill up the vacant seats in the respective courses. All the petitions stand allowed and the orders in WP numbers stand quashed. No cost. Consequently, connected miscellaneous. It is seen that some of the cases, though the students were allowed to sit for the examinations, the results are not being published. The respondents are directed to publish the withheld results. Now, not so far as the facts are concerned. Para 4 captures that. Selection committee represented by its Secretary Directorate of Indian Medicine, Arignar Anna Hospital, Arambakam, Chennai, sponsors the candidates both for government quota and management quota. In all the cases on hand, there was a shortfall in the sponsorship of the candidates by the selection committee. This arose either because the selection committee did not sponsor for the entire intake or some of the sponsored candidates did not join, resulting in vacancies. Such a situation arose either after the second round of counselling or after the mock counselling. From the materials enclosed in the typed set of papers, I am satisfied that the college management had duly intimated the selection committee about the resulting position. Since the seats would go waste and unfilled, respective college managements admitted candidates on their own. Now the question that arises for consideration is whether the said act committed by the college managements is legal or not. The stand of the authorities' response is that the college managements could not have admitted students on their own due to sponsorship by the selection committee that resulted in filing of these writ petitions. When it got special government period appearing for the authority as well as standing council, you're relying on the decision report in 2020 Venkateshwara College. That's how not the situation arose.
Yes.
Submitted that admissions can only be made through the process of counseling, and the college management would not have admitted students and filled up the vacant seats. Now, Lord, what has happened is our position. In fact, in a number of cases, interim orders are passed by single benches.
Why in your case was there a delay in the admissions?
Lord, there was a technical glitch of uploading, Lord. It so happens that during this uploading, sometimes the servers are down. That was the situation in our case.
My lord, I am appealing for respondent number 2. My lord, this case was
23, which was the last date, basically the cutoff date. And on that day, they gave us the details of 42 students. And we then compared that data with the data submitted by Karnataka Examination Authority. And that's when we found out that petitioners 2 to 21, or I apologize, 2 to 18 are not there in KEA's list. That's how we found out that these students have not been admitted through the
To
counseling
counseling.
process. And subsequently, 18 to 21, petitioner numbers 18 to 21, their names are not even featuring in that list uploaded by the college. So those are students who have been admitted post the cutoff date, which means not only is there admission, no admission in the eyes of law, they have been admitted subsequent to the cutoff date.
Prospectus clearly says that it has to be done through the counseling process.
Not just the prospectus, it is the landscape of the law
Correct,
itself,
correct.
starting from the NCISM Act of 2020.
It has to be done through the counseling
Most
process. It
certainly.
cannot be
Cannot
done
be.
by the colleges on
It
their own.
cannot. In that
Now-
respect, if I may
now,
just place.
What prevented them from making the admissions through the counseling process? There's no reason.
No, they did participate, and a few students were admitted through the counseling process.
Yes,
It's
Channa.
just that they had a lot of
20 only.
vacancies.
They did not get the,
Did not
Requisite
choose
intake.
This petitioner college.
Okay.
Students were not.
so it is not
interested
as if they did not have recognition or if
No,
there was
they did
any.
have permission, it's called conditional permission
Yes,
to
that was
admit
there.
students in
Yes.
respect of Ayush courses.
Mm.
And they had it for this particular year.
Mm.
It's a year-on-year process.
Mm.
And for that particular year, that is academic year 22-23, they did have permission to admit 60 students. However, they failed to fulfill all the vacant seats. So they could not admit students because
That's
students did
20.
not choose that college. And then post the cutoff date, they went ahead, admitted students on their own at
Without,
the institution
without
level
reference to the counseling process.
process itself. And in
The
that respect,
students are those who have taken the NEET. They are
I
eligible
am
and
not
qualified.
aware because
You-
these are only
Statement of
through the college. And that is why I would like to place the regulations on record as well, if I may.
We have said, that they are
Hand
NEET
over a
compliant. We have said, Lord, they are NEET compliant. They have complied with me.
So now, as a matter of fact, these are students who have been admitted
Yes.
under some procedure,
Yes,
who are undergoing the examinations, who do have the benefit of interim orders.
yes.
So when they, my main grouse in this case, your lordship, is that these students were admitted in violation of law. Secondly, they have approached the court lacking in bona fides, entirely lacking in bona fides, because they did not make NCISM a party. They did not make KEA a party. And these are the only two bodies which would have the relevant information. So when the interim order granting them permission to write the exams was given, they had suppressed two essential factors. One, they did not make us a party. And secondly, there was a communication that was issued by NCISM to the petitioner institution in May of 2024, 27th May 2024, stating that these students, the 16 students list has been given. We asked the institution to cancel their admission in order not to waste the petitioner students' time and not to waste their monies. They have suppressed that document, approached the court without making us a party, and persuaded the court for an interim order. So they're completely lacking in bona fides. And in fact, it is my humble request that this is a petition to be dismissed with exemplary costs. It's a
Right.
complete fraud. And I would like to canvass some more arguments in this respect. And I've also produced judgments of the Supreme
We'll
Court
hear
along
you
with
on
my
that.
compilation.
Just a thought that we have. Who has, obviously, your contentions are against the petitioners. So is it a fit case where we can probably impose some costs on them and permit the students continue their
Unfortunately,
education?
if I may submit, this honorable court has in some situations considered such remedies, but that is when the college did not have certain infrastructural requirements and that was fulfilled. But this is a case where it would be really hard to say that the petitioner students themselves were not aware of what is going on, because they knew very clearly, and ignorance of law would be no excuse, that without participating in a counseling process, they cannot get admitted to an institution. And the requirement of the law is to prevent backdoor admissions. We do not want to entertain any backdoor admissions. We want to keep it merit-based. And that is a complete legal landscape. Section 14(3) of the NCISM Act, read with the comprehensive guidelines on counseling that has been issued to the institutions as well as the universities, specifically states that there will be no other admission. In addition to this, the minimum standards of education 2022 regulations stipulates that there is no question of any kind of admission other than through counseling only. So especially in a fraudulent case where there is mischief played on this honorable court, it is my humble request that the
Sorry
petition
to
be
say, it is
dismissed
not
with-
fraudulent. These are students, Prakash. The students could not go through the counseling process, but they are eligible through NEET. Why the counseling is placed, Lord, is so that there is an order of merit.
The counseling process is as an essential
Yes.
requirement of the admission process itself.
Yes.
Then can you get away by saying
But-
that these are persons who have
Yes.
NEET
Yes, ma'am.
qualifications?
Yeah,
Why
precisely.
is there a counseling process
precisely.
provided?
Actually, the counseling is provided so that persons in order of merit are allotted to colleges and the colleges don't underscore merit. That is why the counseling process is there. But through the counseling process, they have not been able to give us sufficient students. They have only been able to give us 20 students out of 60. And after the counseling has closed, that is what they say, but when students come to us and we admit them and they are NEET compliant, what they require is only NEET. We have complied with NEET block. And we have qualified through NEET. Now, let students, it will be difficult if the students are asked to suffer.
When are the examinations?
Examinations.
They have written examinations.
They have written
Results
examinations.
are not
ma'am.
application.
It is
Results,
the
we have-
result that have.
Yeah, result has to.
You have to hear.
Uh,
this. Yes.
Lord, I am representing the Union of India. So we are the ones who pointed out that R4 is the necessary statutory body.
Hmm.
And I endorse the submissions made by my learned friend. And on the conduct, apart from what was submitted, Lord, the orders passed by the learned single judge will be contrary to the roster system. These are all medical education matters. So typically the classification will be education, admission, ADM, MED. Essentially, it should have gone before the division bench. So the way it got listed before the learned single judge, the way in which the NSIM was not made a party, we have to make. So I think this conduct, merely because they are students, they can't
I have brought it before the division
they
bench.
can't
Others
be
have not brought it.
given the benefit that with the right to admit without undergoing the statutory process is something which goes to the root of the matter. So the matter may be heard and then the writ petition itself may be disposed of instead of granting any interim.
Yes. When do we hear this?
Lord, in the meantime, there is one single judge order, which has also said declare the results and permit them to pursue their.
We'll consider.
If I may,
We'll consider.
submission in that respect,
When do we hear this?
Just give
I
it
beg your pardon,
Wednesday.
When do we hear this matter?
21st or 23rd or any other date.
23rd?
No, Lord.
23rd, definitely, it's a Saturday. If anybody,
23rd.
if anybody is ready on 23rd, we'll
But
never say.
23rd, I have some difficulty, Lord. But Lord, classes are commencing.
No, but it's a sitting day.
Yeah,
23rd
it is a
is
sitting
Which is why we said
day.
that if anybody is ready on 23rd, we are only too pleased
We can have it on
because normally it's difficult to get people to.
27th, Lord, 27th.
27?
Can be,
Yes, please.
yes. So
But
if
at
there is,
least-
if there is any synopsis that you
I've
want to
already
explain,
At least if
handed
the
over
results
the-
are declared in the meantime, that
I
much.
would object to that.
Yes,
let us decide it one way or the other,
yes,
either way.
yes.
Great.
I may have to point out a certain fact. So in this case, the matter was posted before a division bench, but there are two other matters on the same issues where the matter is pending before a single judge, although as per roster, it should be
The facts would be different.
okay, different colleges, but the issue is the same, admissions. Respect of.
But they could be also brought here.
Yes.
They could be also
Give
brought
the
here.
numbers, so that they can also be.
But may I request that they are not tagged, because if they get tagged, then nothing will.
Right.
Maybe posted on the same day, but separately.
Fair enough.
Can be tagged.
Numbers could put it.
I think I would have to also make that submission before the learned single judge so that he can send over.
Why, Lord, Lordships could summon it,
Post, list these two matters along with.
please.
But when you say along with, the problem is that it may have to be tagged.
No,
It can be tagged, Lord. It can be tagged.
Listed on that day.
sorry,
Yes.
just give the numbers. I'm grateful.
Grateful.
Please, please. God bless.